Good morning. I am Councilmember Zachary Parker, Chair of the Committee on Youth Affairs. Today is November 19th, 2025. We are meeting in room 123 of the John A. Wilson Building and virtually via Zoom. The time is now 10:33 a.m. and I'm calling to order this hearing on the Committee on Youth Affairs. I want to start by acknowledging this is the second hearing that the committee has had on a number of bills presented in the Care for Youth plan that I introduced last month. During today's hearing, we will hear testimony on 4 bills referred to the Committee on Youth Affairs from the Care for Youth plan. Those 4 bills are B 260398, Increasing Support for Grandparent and Close Relative Caregivers Amendment Act of 2025, B 26-0406, Streamlining Services for Children Amendment Act of 2025, B 26-0409, Empowering Parents and CFSA Investigations Amendment Act of 2025, and B 26-0412, Child Abuse Investigation Multidisciplinary Team Certification Amendment Act of 2025. These bills seek to uplift, inform, and streamline a number of issues related to the Child and Family Services Agency, or CFSA. These issues were primarily born out of my committee's extensive performance and budget oversight that brought them to light. My hope is that with these bills, we can continue to create a child welfare ecosystem in the district that provides supports for parents, children, and caretakers alike. Now I will go through and describe at a high level each of the bills under consideration today. First, the increasing support for grandparent and close relative caregivers. Throughout budget and performance oversight, I heard from grandparents and close relative caregivers about the immense burden they take on. These are family members who step up to take care of children into their home at a time of immense need for the children. In particular, I heard of their struggles financially and the ever rising cost of childcare in the district. The Increasing Support for Grandparent and Close Relative Caregivers Amendment Act of 2025 seeks to address those financial struggles directly by increasing the rate of subsidy provided to grandparents and close relative caregivers, adjusting that subsidy for inflation annually, and increasing the age allowed for the grandparent and close relative caregiver subsidies to be granted until the child in their home reaches the age of 21. Currently, that age limit is 18. Second, we have the Streamlining Services for Children bill. The youth services system in DC exists as a very complicated web lacking clear leadership and directional structure. This legislation addresses this issue by creating an office within CFSA to analyze and make recommendations on the existing patchwork of services and programs aimed at streamlining them to support children and families. The bill also creates an interagency council to ensure clear coordination of services at the highest levels of agency leadership with input from stakeholders. By better aligning these services, we can create a more effective and efficient network of resources for families who will be able to access benefits without undue delay. I think it is also worth noting that CFSA is not unique in serving as an agency with a complicated web of resources, programs, and services. I think that can often be said about many agencies and programs in district government. Third, we have the Empowering Parents in CFSA Investigations Bill. Many parents facing termination proceedings relating to charges of abuse and neglect are not made aware of their right to counsel or other available resources until later stages of a CFSA investigation, when it is more difficult to gather appropriate evidence and prepare a defense. This bill seeks to inform parents whose children are the subject of investigations by CFSA of their rights and resources prior to the initiation of any legal proceedings, thereby empowering parents to have more ownership in these proceedings and for them to be aware of their rights. And then lastly, we have the Child Abuse Investigation Multidisciplinary Team Certification Bill. As many know, the Safe Shores organization now serves as the primary Children's Advocacy Center, or CAC. for multidisciplinary team or MDT investigations. This legislation would guarantee that any organization chosen to serve as the primary CAC for MDT or multidisciplinary team investigations will be sufficiently vetted through accreditation. To that end, this legislation will mandate rather than request the involvement of an accredited CAC and regulate its participation in MDT investigations of child abuse. This bill ensures that vulnerable children in the district are guaranteed the standard of care and services they deserve. And I just want to take a point of privilege here to discuss this. There has been a lot of angst behind the scenes about this bill in particular. I want to note that I am a big fan of Safe Shores as an organization. I believe they do incredible work. I believe the role of a Children's Advocacy Center is one that we should raise the bar and maintain the highest levels of certification and vetting, as these entities are chiefly responsible for investigating allegations of child and sexual abuse. And the intent behind this bill was not and is not in any way meant to undermine Safe Shores as an organization, but to ensure that we can maintain a standard of excellence in perpetuity. In conclusion, together these four bills advance meaningful changes within the district's child welfare system, all with the goal of stabilizing caregivers, empowering parents, protecting children, and ensuring every child and family in our city has access to the resources and support they need to thrive. I want to thank all of our witnesses who will testify today to help us refine and strengthen these bills. I look forward to our conversations with the shared goal of improving outcomes for vulnerable youth and their families. Now, I will begin calling up public witnesses. Each witness will have 3 minutes of testimony, followed by a round of questions, and then our government witnesses later will be Tanya Torres-Trice, the Acting Director of the Child and Family Services Agency, as well as Patrina Jones-Jez, our Ombudsman for Children. And so first, we will have Melody Webb of Mothers Outreach Network, Amy Allen, Mothers Outreach Network, April Thomas of the Mothers Outreach Network, and Angel Brand of the Mothers Outreach Network. Only seeing 2. I'm going to keep going. Yasmin Holmes of the Mothers Outreach Network. Sharon Harris of the Mothers Outreach Network. Diamond Gabriel of the Mothers Outreach Network. Maka Taylor of the Mothers Outreach Network. I will stop there. And I am not seeing anybody online. So, Melody Webb, you may begin.
Good morning, Chairman Parker and committee members. My name is Melody Webb, and I head Mothers Outreach Network. We provide representation to parents during CFSA investigations, as well as engaging in policy advocacy. Thank you, Councilmember Parker and committee, for championing this bold legislative effort. We're excited about the promise that Empowering Parents in CFSA Investigations Amendment Act of 2025 represents. To strengthen the bill, we have some recommendations. Parents should be provided guaranteed pre-petition legal counsel and representation. Parents should be informed of their rights by independent legal counsel when an investigation ensues. They should be provided with information for relevant and non-CFSA connected independent legal defense counsel. CFSA should inform parents in writing at the inception of the investigation of the reasons for the investigation, the date by which the inquiry is scheduled to draw to a close, and subsequently of any extensions that are deemed necessary. Upon conclusion of the investigation, CFSA should provide written notice to the parent that the investigation has happened. Data related to complaints regarding the investigation process should be maintained by the ombudsperson and disclosed to the public. Pre-petition parent representation should receive guaranteed government funding. And why? Parents have a constitutional right to establish a home and bring up children under the 14th Amendment. They also have a right to direct the upbringing of children under their control. The Supreme Court recently opined that this parental right is perhaps the oldest of the fundamental liberty interests. In DC, the Fourth Amendment right against search and seizure, including on entering the home, applies to CFSA investigations. In August 2022, the American Bar Association adopted Resolution 606, which calls on all legal professionals to recognize how over-surveillance of and underinvestment in Black families has shaped the child welfare field and should be examined and addressed. Nationally, the numbers are staggering. 53% of Black children, 28.2% of white children experience an investigation by a child welfare agency by their 18th birthday. Upon information belief, CFSA routinely violates the constitutional rights of families involved in child welfare investigations. These violations compound existing inequities, and parents who face investigation have difficulty asserting their rights because of the ever-present threat of family separation. The investigations are often highly traumatic for the entire family, and the stress and fear they create is a barrier to self-advocacy. As a result, children are unnecessarily separated from their parents and removed into foster care, and families experience lasting and avoidable harm. In New York, one of the pilots I'll describe briefly, certain child welfare agencies have participated in a pilot program since its inception in 2002. The program provided pre-petition independent legal representation to parents in child welfare investigations, and the results were incredible. In the program, nearly 50% of cases were entirely kept out of foster care. And in 2014, children with cases in the pilot program were in foster care for an average of 5 months versus a statewide average of 29 months. Pre-petition right to counsel is a critical intervention to prevent due process violations of family separation by hidden foster care. These practices are often coercive, so much so that they may violate parents' rights to due process. Early pre-petition access to counsel during the investigation phase disrupts the status quo of harmful systemic abuses of families' rights, entirely preventing needless and traumatic family separations. Thank you for the opportunity to testify.
Thank you. Angel Brand. Just acknowledging again that Amy Allen and April Thomas don't seem to be here. Oh, I'm sorry, you are Amy Allen. My apologies. Why don't we have you first and then we'll go to Angel Brand. And if you can please speak into the microphone as much as possible.
Good morning, Chair, members of the DC Council, constituents, colleagues, and citizens. My name is Amy Allen, a 25-year Washingtonian, working 25 years for various laboratories in the DMV, degreed in criminal justice, a taxpayer, mother of 3, and also a grandmother of 2. Currently a member of and advocating with Mothers Outreach, AJE, the Washington Legal Clinic for the Homeless, Fair Budget Coalition, and Spaces for Action. Formerly, I held the parent board member position at my daughter's school. I'm here to strongly support Councilmember Parker's Bill B 26-0409, Empowering Parents in CFSA Investigations Amendment Act of 2025. My teen daughter began showing serious mental health symptoms at a very young age. Dangerous behavior, personality changes, sleepwalking, and later severe anxiety and refusal to leave the home. For years, we were bounced around wait lists, lost referrals, and a shortage of child mental health providers. She was eventually diagnosed with agoraphobia and social anxiety. Then during a crisis last year, panic disorder was then added as the third diagnosis. Once assigned to a provider, meds were prescribed. This made the transition from virtual learning into a therapeutic boarding school a reality. When my daughter was medically sidelined and her mental health flared, her school exercised their ability to work with us virtually. Unfortunately, a temporary psychiatrist refused to approve virtual schooling or to even excuse absences, although my daughter was in crises. The school ultimately involuntarily removed her because of it. In turn, I was removed as a parent board member, and there were no comparable placements suggested or available to her. That triggered CFSA. I had 2 CFSA investigations. The first case was dismissed because I had a lawyer and was going through the process of seeking school placement. As soon as the case closed, a second case opened. The new case was claiming educational neglect and also myself being accused of Munchausen's by proxy. I sat through hours of intrusive questioning, was asked if they could follow me home to search my refrigerator, and was treated like a suspect instead of a mother fighting for her child's life. Both cases were closed with no findings. The damage, fear, and stress were real and ongoing. I did everything right. I sought help early. I followed medical advice. I followed up. What nearly broke us were the gaps between agencies, the lack of mental health capacity, anonymous reporting with no accountability, and CFSA practices that punish parents who are trying to get help. Councilmember Parker's bill is critical because it shifts power back towards families, requires CFSA to operate with more transparency and accountability, and helps ensure that parents seeking services aren't treated as criminals. Every family situation is unique. Programs should offer wraparound services for children and parents, not push them into a pipeline of fear and punishment. I urge you to pass B 26-0409 so parents like myself are empowered and respected as parents, not targeted. Thank you for your time.
Thank you for your testimony. I want the record to show I'm pretty lenient with the clock, but if you all could just be mindful of the clock. But thank you for your testimony. Next, we will have Angel Brand. And if you can make sure the light is on.
It's on.
Okay.
Good morning, Chairperson Parker, and members of the committee. My name is Angel Brand, and I am a mom's outreach advocate with mom empower advocate with Mothers Outreach Network. I live in Ward 7, and I'm a proud mother of 9 children. Today, I am testifying about empowering parents in CFSA Investigations Amendment Act of 2025, because this issue affects families like mine and many others in our community. I am testifying today because I believe the legislation will improve the current system for families involved in child welfare investigation by reinforcing parental rights and potentially clarifying the investigative process. If lawyers had been available to parents during the time of the investigation, it would have been easier for parents to fight for their rights and their children. This is an urgent issue because families are being torn apart. Based on my experiences, I recommend that the council require the CFSA to inform caretakers of their legal rights, including access to free legal services and counsel at the start of the investigation. I also recommend that the council direct CFSA to notify caretakers about the office of the buzz person for children as a resource for complaints. This will help families like mine by empowering parents and by keeping families together. Thank you, Chairperson Parker and members of the committee. Thank you for the opportunity to testify.
Thank you for your testimony. Next, we have Yasmin Holmes, who I believe is online.
Good morning, Councilmember Chair Parker and members of the committee. My name is Yasmin A. Holmes, and I'm a single mom of 5 boys, all age 6 and under. I was born and raised here in D.C. I live in Ward 8, and I grew up in the foster care system. Today, I'm here representing Mothers Outreach Network, where I am a Mom Empire Advocacy Fellow and a participant in the Mothers Up Guaranteed Income Pilot Program. The Mothers Up program has been a lifeline for my family. It provides extra cash with no strings attached. I'm sorry. Um, the support that helps us meet our basic needs and breathe a little easier. But I know it won't last forever. I want to thank Councilmember Parker for, I'm sorry. I want to thank Councilmember Parker for all his hard work, and I want to speak today about the start of the investigation, having legal services for a start of the investigation, and how it affects and not support the mothers during that investigation. And I also think that the start of any investigation, I think legal representation is very important because we are scared, we don't know what to say, and we are uncertainty of what to do in any situation like that. And um I also believe that if we have the right guide in situations like that, I think it would stop separation from family, and I also think that we would have more resources and we wouldn't be so afraid to go through the investigation. We would also feel like we have a little bit of help. So thanks again, everything, Chairman Parker.
Thank you for your testimony. Next we have Mika Taylor.
Good morning, council members. Hello again. I thank you. I did call your office yesterday. I'm emotional because I experienced something like this and I forgot how far down I had buried it. But I'm going to read my testimony. I'm only here as a parent. I'm representing the Mothers Outreach Network. Again, forgive my voice. My name is Mika Taylor, and I'm here as a mother who survived something that could have destroyed my family. Not because I was abusive, neglectful, or absent. I was vulnerable. I had a self-diagnosed nervous breakdown. I went to the hospital because I needed help. I told the truth about the level of distress I was in, the kind of emotional weight many parents carry every single day, silently. And what did the mandatory listener hear? Not struggle, not exhaustion, not humanity. They heard danger and abuse. A cultural misrepresentation that opened the door to an investigation that changed my life. I did what so many parents in crisis are forced to do. I educated myself. I sat down and I read the statute I was accused of violating. And as my case moved from investigation to appeal, I discovered that something that shook me. The statute had already been changed before my hearing. Definitions updated, harmful standards clarified, rights that should have protected me quietly shifted. Yet I was still judged under the weight of poverty, isolation, and an untenable, unnatural living situation. Not under the reality of law as it stood, but under the assumptions people made about a mother breaking down. See, this system is very quick to investigate us, but very slow to listen, and slower still to empower. But I stand here today because if God be for me, who can come against me? I am not ashamed of surviving. I am not ashamed of needing help. I am ashamed only of how easily a system built to protect can misread a parent who is simply fighting to breathe. That is why these bills matter, not in abstract, but in real lives like mine. B 26409, Empowering Parents in CFSA Investigations. This is the bill I needed. Parents must be told their rights from the beginning, clearly, compassionately, without intimidation. I want to clarify respectfully. The right to a lawyer should be pre-petition, right from initial CFSA contact and during the investigation. This bill is a good step in the direction, but it seems to say you get informed to a right of counsel after the case is filed in court. That is too late when your family has already been seemingly harassed or absolutely subject to a trauma that it is unable to support or with proper cause for action. I deserved, and all parents deserve to know they have a right to counsel, support, information, and a fair process. B 26412-412, Child Abuse Investigation, Multidisciplinary Team Certification. We need trained, accredited, trauma-informed teams when investigators on a line or equipped, families pay the price. This bill brings professionalism and accountability where it has been missing. Would you like me to stop?
No, please keep going.
B 26-398, increasing support for grandparent and relative caregivers. Family saves family. Relatives step in long before government ever does. Strengthening them strengthens all of us. Another service that could have been helpful in my situation, streamlining B 26-406, streamlining services for children. This matters because parents don't need to run a marathon across 4 agencies just to keep their household stable. Coordination is dignity, access is dignity, and dignity is protection. My suggestion is proper aggregation of data to organize, sort, and input as needed. Now, the question I ask in every hearing, who is this happening to? Let's be honest, the demographics tell a very clear story. Investigations, removals, and misinterpretations fall heaviest on Black, low-income families, mothers in crises, and parents who don't have lawyers, degrees, or connections. If these bills don't pass with proper markups, these are the people who will continue to be harmed. So the real question is, who is protected? Who is being missed? Who is this designed for? And if not for the people most impacted, then why are we doing it? It is my personal suggestion to empower parents who are present, create a peer support network and ecosystem within the framework, and really assist those who are absent and struggling. Because investigation should not be a punishment for asking for help. I am proof of that, and I actually CPS myself the other day, again, relative to the situation with my children. We are families in crisis, and I urge you to use the lived experience experts to properly mark and pass these bills, not as policy, but as protection, not as paperwork, but as justice. Thank you.
Thank you for your testimony. And my team did notify me you called yesterday.
I'm calling them every day.
No,
They're not at school today either.
They shared that. We welcome it.
Thank you.
Next, we have Diamond Gabriel, who I believe is virtual.
Yes, good morning. I'm outside, so I'm sorry if it's a little noisy. But good morning, Council, Chairperson Parker and Pitzo, and members of the committee. My name is Diamond Gabriel, and I am a Moms Empower advocate with Mothers Outreach Network. I am a proud mom of 4. Today, I am testifying about empowering parents in CFSA investigation because this issue affects families like mine and many others in our community. When a CFSA investigation is started with the family, oftentimes they are confused and unsure of the reason for investigations. Families in poverty are mostly targeted and oftentimes do not understand the legal system, their rights, or the resources available to them. This issue is urgent because CFSA investigations add more stress to families who are already under an incredible amount of stress. It can lead to parents feeling anxious, depressed, and scared. Based on my experience, I recommend the DC Council for CFSA to offer more legal services to families struggling through investigations. This will help keep families together, keep them strong, and keep their children safe and happy. Thank you for the opportunity to testify.
Thank you for your testimony. We're going to stop there for now. And I'm happy to open up for a round of questions. Ms. Webb, can you speak to your experience as an organization representing and supporting parents going through investigation by CFSA?
Yes, and you've heard it from the moms here. Parents are often confused about why they're being investigated. They contact us because they want more information. They're worried, they're afraid. The ones who do reach out to us are very courageous because parents are also feel that they're discouraged from seeking legal help. Our organization, to my knowledge, is the only legal services organization that represents parents during investigations. And we are just, constantly surprised by parents not having enough information about when the investigation started and when the investigation concludes. And so what we do, and I do commend the agency for designating attorneys within the agency for us to contact to obtain information, to speak with a social worker on the case. And we unfortunately often don't get any notification of when our clients' matters have, the investigations have concluded.
So am I supposed to interpret that as a parent, a mom is usually reaching out to you to say, I need help, I don't know what's going on. You reach out to CFSA and then they just don't hear back?
They don't hear back and we don't hear back either. And we think that, as I suggested in my testimony, that using documentation would be helpful, informing parents, with a written notice. Parents talk about hearing about these investigations for the first time from their children, and they just feel helpless and bewildered.
And I can imagine a level of stress that causes one to be under investigation, but not knowing if and when that ever comes to a close has to be immensely stressful for parents.
It certainly is. And they feel overwhelmed and they will ask us what their rights are. They don't have any information about their rights. But the ones, again, who do reach out to us take some level of comfort that they have some representation and spokesperson to be their liaison, to talk with the agency on their behalf. And we do that to the extent that we're able. I believe that in recent months, we've seen some progress and responsiveness on the part of the agency when we've reached out. Social workers, we've had occasion to speak with them. But unfortunately, we have had an incident where we represented a parent and the matter progressed, unfortunately, and we were in conversations and meetings where we experienced the agency repeatedly berating the parent for having reached out to counsel. And so we're very concerned that under certain circumstances, that parents may be discouraged from seeking support from Mothers Outreach Network.
Understood. And I know part of your testimony is that you believe the legal representation is coming too late. Can you speak more to that?
Absolutely. If a parent can understand the basis for the investigation and have clarity about that, obtain counsel, they may be able to cure the issue. They may be able to, through counsel, gain a better understanding, address the problem, and then the problem might be mitigated. However, if the parent is not aware, the parent shuts down out of fear, then the case will unfortunately potentially progress. So if parents had an awareness of their what the situation was that led to the investigation, and received advice with regard to how to respond to it, we believe that the stress level for the parent and therefore for the entire family would be alleviated, and the problem could be addressed. And as I mentioned, in pilot programs around the country, there's been a dramatic drop in the number of cases that went to foster care as a result of these pre-petition investigation stage legal representation.
And where are those pilots again?
So though they include New York, Michigan, and Washington State.
Got it. Okay, thank you for that. Micah Taylor's, you had mentioned, Ms. Taylor, the need for a parent peer support program. Can you elaborate when that type of program would be most beneficial for parents or moms?
At this point, I would absolutely say it's beneficial in the right now. It has been my experience, for whatever reason, that what I needed, I was speaking to it, but it was not, nor were any policies progressive enough to even be looking. So even in the instance that I spoke to, what I was speaking with them, I was overwhelmed. I'm the sole provider for my children, have always been, and I'm a transplant. I don't have family. And in St. Louis, we had something called a crisis nursery, which was if a parent was going through something, they had up to 72 hours where there was a place you could take them if, again, in crisis that was necessary. for me to.
Take them to drop them off?
To drop them off for up to 72 hours. So at that time, I knew that I was overwhelmed, like my body was, I was physically responding to the stressors in my life and going through that. But I think that if there were a way to create that immediately, and me, again, I have over a 20-year history in nonprofit organization, kind of nationally from St. Louis, I've conferenced, so my personal body of knowledge is actually what kind of assisted me on the way. It was not anything in program. It did come after the fact. So I will go ahead and say I'm typically ahead of my time in this particular space on what's needed. And even what you're speaking to are things that I had been kind of pushing for one way or the other. And I do point myself out as an absolute reference and asset to all of that programming. What you saw, I have not dealt with that. My children are now 15. That instance happened when they were still in diapers. I guess that I had not exactly processed how painful it was. That was an initial being a transplant, a new mom to twins, and then having what you would call an emotional, socio-emotional relationship with my twins' father. That was an initial contact with CFSA in that arena. And for it to go that far, it was just
What's
overwhelming.
most traumatic, not to cut in, what you're sharing is you're seeking help per your story and you're being punished for it. Essentially.
Absolutely, that's
That
what happened.
triggered an investigation.
Absolutely. Absolutely. I actually I'm a negligent parent on paper as a result of that incident.
Wow. Wow. Ms. Allen, I wanted to come to you. Can you just walk me through the stages of the investigation process that you experienced as a parent?
Okay, so the first instance was right after my daughter's IEP meeting, February 2025, where everyone, the school, the psychiatrist, the temporary psychiatrist, both parents, the legal representation, we were trying to agree that virtual learning would be the thing temporarily until we can figure out the situation with my daughter. That doctor said no. And that meant that no virtual learning, no nothing. So that
Because
is
you
what
were
triggered.
attempting to get a diagnosis for agoraphobia.
Well, we were trying to get her to go to school in person and she was flat out refusing. So that's.
What's the age?
I'm sorry.
What's her age?
She's 15.
15. Got it.
So 2020 had really did a thing with my daughter. She was already exhibiting mental health concerns when she was about 6 or 7, and her providers then knew what was going on. They told me, yeah, mental health, she needs to. So fast forward, no, couldn't link with mental health providers, and then pandemic came and everything just spun out of control. And then so to fast forward, virtual learning was not agreed upon, and the school had to voluntarily remove her because the doctor would not approve it. So that meant any excuse, any absence she had, they were all unexcused. So when she reached the 20th day from that point, and mind you, she was doing virtual leading up to seeing the doctor. It's a whole nother story. It's very layered, my situation, unfortunately. But this provider said no. So that's what triggered the school to start the first CFSA case. That first case manager reached out to me, and he was very respectful. Actually, we communicated and he said, yeah, you have a lawyer, you're seeking, help for your daughter. This is not physical or verbal abuse. This is not you. This is your daughter being mentally ill and you're trying to get help. So I'm going to close the case. So I asked him, can you please put that in an email and send it to everyone that's on the thread? And he did. As soon as that IEP meeting in February 2025 was over, another case was presented to CFSA. That's where the educational neglect and the I can never say the word right, Munchausen by proxy, Munchausen by proxy, that's where they was trying to say that I was mentally ill and that I was diagnosing my daughter,
Mm.
or I was adding more onto than what it was. But these diagnoses came from her provider before the temporary doctor took over. So that really threw me off. But
And how were you notified of that? And so caseworker sends email, this is closed. Then I'm assuming
It
weeks
was-
later.
it was literally a few weeks later.
Weeks later,
someone kept coming to my house,
got it.
and I'm not home. I work all the time, so I'm not home. I'm catching it on my Zoom. I mean, on my security cameras and stuff. And
Mhm.
you know, my daughter, sometimes she was home and she's like, someone's at our door and I don't know what's going on. And you know, and I said, just don't go to the door. You know, let me figure it out. So I reached out to that initial case manager and I said, question. I'm just out of curiosity,
But were they leaving any information? Did
No.
they share, I'm with CFSA?
no,
Okay.
in my security camera, this person, for one, didn't identify who they were, but they were going to my neighbors and I can hear the person say, do you know Miss Allen? Is she here? And they was like, no. And that's what really triggered me to reach out to say, okay, what is going on? Because I saw an ID around the lady's neck and everything. So I reached out to the first
got
case
it.
manager and he said, no, your case is closed. Come to find out that person was also from his department. So that's what triggered their superior to comment and say, yes, you have another case. Can you come and talk to me? Or can we come to your house? And I said, no, you cannot come to my house because I don't have any information. And to my understanding, the first case was closed. So with a good friend and also someone that, you know, he's a therapist also, he accompanied me to visit CFSA. When the conversation was great, when he had to leave an hour into, the conversation changed. It was just me and this person, and it was, you know, can I follow you home? Yeah, I need to see if if you have food in your refrigerator. I need to see how your daughter is kept. Is her clothes clean? And then slid me a piece of paper with all these services. And I'm looking, I said, what is this? And she said, well, just in case you need any services. It was almost like she was playing good cop, bad cop, like trying to help me, but at the same time trying to see if I had any deficits in my household
Hmm.
or if I needed
So
certain.
did they ever come out to investigate?
Well, my daughter is agoraphobic, diagnosed by her previous doctor, who, it's another situation. They end up dropping her, and I had to get on another wait list. And now she's back on, and we just had an appointment yesterday. So, the thing is, the provide. I'm not going. The language that was used in what they read to me in the office is the same language that was used to me with this person. And I can't quite say because I don't know for a fact, but I'm not stupid. I know what someone tells me, and when you read it back to me, I immediately told
Understood.
the case manager, I immediately told him, I know who it is.
So to your knowledge, is the investigation ongoing?
It's closed. So
The second one is now.
the second is closed.
So you were notified that it was closed?
Well, they left a voicemail. No paperwork was ever given to me. So in that meeting, that 3-hour meeting that I sat in with, she was asking, can I give any phone numbers and names of people that can validate me? So I gave actually the director of the school that she's at now, and which she was there prior to going to the therapeutic
Mhm.
school. So I kept a relationship with the prior school all this time because they were concerned about, they knew what was going on for my daughter. So reluctantly, she's back at that school for high school, but I gave them names of her therapists, of other providers.
That they did call
followed
to say this, because
everybody.
part of the testimony I've heard today is that parents never hear back when the investigation is closed. And now you're giving 2 examples when, in fact, you are being notified that the investigation is closed.
It was a voicemail. It was a voicemail.
But you're still
Yes,
notified.
yes.
Yes.
It was a
Okay.
voicemail.
But that's good. That's good news. And because I would imagine that's stressful to have that just lingering out there. Ms.
Yeah.
Taylor, were you notified when your investigation was closed?
Yes, every investigation that I had, I was notified.
Was it in writing or verbal?
I do not recall. I had several investigations over the course of years. I do know that, I believe maybe one was in writing. The others may have been, I believe the caseworker did just reach out, but not for nothing. I'm a very gregarious, like kind person. So most of the people that I worked with, we kind of, like, we weren't friends, but they would let me know everything that I needed to
Understood.
know, if that makes sense. I advocated for myself and they treated me as such.
Understood. Well, thank you. I've taken a little bit of extra time here. And I think it's warranted you all come and bare your soul with some very personal experiences. And I say it and I mean it. Please reach out if there's anything we can do, to support you and your situation. We're happy to do it. So thank you all for your testimony. Next, we have Tyler Dukes of Mothers Outreach Network, Dahlia Allen of Mothers Outreach Network, Dion Thomas, Dante Massey, Leah Castellas of Children's Law Center, and we will stop there. Is Chris Gamble here? Okay, yeah, we'll stop there for now. Now, our chair. Are you Tyler Dukes? Yeah. Uh-oh. Okay. Understood. We'll come back. Let's jump to Dion Thomas. Yep. If you could just push the button and make sure you speak into the microphone.
Thank you. My name is Dion Thomas. Lifelong Washingtonian. I just hear well, this is this years I've wanted to I'm 49, so but I see it as important to talk about issues because this has been an issue in my family. I just want to say, out of 400 years, it's relevant to us. I can speak for all Washington. Out of 400 years of slavery, we've been oppressed, in DC alone, oppressed, without fathers. I grew up without father in my house, so and wanting him there, but always visiting. It was traumatic for my mother, and stressful can be real hard. And when you're going outside, not knowing if you're gonna live or die is a reality to us. Stress on parents, especially single mother. I have 4 sisters, they having trouble. And I can say that in situations when families are going through things, if you can allow other relatives, family structure is important. Let other relatives somehow assist with them and legal terms and help with, because I have a sister that's going through, she's been going through for 5 years, not on her own, but she's single and the father is not really helping. I do my best and it's stressful. And a lot of times I have to cut my stuff to go and help her and calm her down. And children and peer pressure, negativity, media, everything that's going around. And she's trying to do her thing is overwhelming for the family. So if family members that's not involved with the case, but relative, cousin, brother, whatever, or can insist, important for DC to provide housing, law, where, because like my sister, I had to help her to say, okay, listen, what is the law or what is they saying? This or that, she tell the child, she go to school and the kids, they're pressure. We're talking about children. They're pressure. They're not adults like us. When I was young, I made mistakes. Growing up, how can I do that, But they're impressionable. And when the mother is stressed, the children are stressed. And it's overwhelming for us, I can say as well. I grew up in the 80s, the drug epidemic, the murder capital. You know, it was better. Only way we survived was through God. Wasn't the police, government, nothing. But and we speak for a lot of us can say that, but we survived. But the family is so broken, that's what's so devastated.
Hmm.
If you can provide for families to somehow, okay, to support, and okay, if they're going through something, let them take care of them for a minute and to get it together. But you know, emotional support, or we have to keep the family together. And a lot of parents are going through so much, they may say, I don't care, and just give up. It's not their fault, because I done been through stress. I done been homeless, doing all this and struggle to get by, and I have children. And it hurt me just not to be there. But we have to find some solution to keep the family together, and because they don't want to tell you your rights and everything.
So if I were to, we're at time, but if I were to ask, what is the headline of how we can support the family structure in supporting kids?
Okay, like I was
Because
just
I
hearing,
think that to heart.
okay, if I was just hearing a lady saying, they were saying this and all that. If it's a situation where if they have to, first of all, legal representation is very good. They need to know their rights. Because if they're stressed, you can't answer questions when you're under stress, or you're going through things you may feel like they're not going to help you. I'm hearing people, I just hear people, and I hear it a lot in the streets. I don't want to use like a neighbor, but and she said, oh, they're not going to help. They're going to try to say this and that, but it's not that, because you're under stress.
So you would agree that legal representation while a parent is under investigation is a good thing?
Exactly. They should get that first. And go and that they need to get that guaranteed. They have their own personal lawyer. And then if it's a case where as though the children have to be taken out the house or whatever, first see if they have a brother, sister, cousin, whatever, that can help them. Okay, if they're working, it may be, I'm not gonna say it's too much, but help them get a job. Or if they don't have housing is very important.
Understood.
And if give them that and find and keep it together, and also give legal and I don't want to say disappointing thing, give parenting skills, stress, cope, and help to deal with things, life and skills. Give them, don't judge them because they don't know this. Because we
Understood.
grew up with our family and broken home in our environment, you know, and this was coming not because what we did, it just was put on us. It's overwhelming living in the community, but we have to survive. So give them the help and support. The government here to help to support the people. We're not here culture. We're just living here and dealing with what we're going through.
Well, thank you for your testimony. If you stick around, I'm going to ask everybody some questions, but thank you for your testimony. If you could just push that button so the light turns off. Thank you very much. Next, we're going to go back to Tyler Dukes.
Good morning, Chairperson Parker and members of the committee. My name is Tyler Dukes. I'm a mom's empowerment advocate with Mothers Outreach Network. I live in Ward 1 and I'm a mom of 7 children. I'm here today in support of Bill B26-398. I was raised by my grandmother in Ward 5, and I believe grandparents can provide emotional support when parents are unable to be present. They often take on responsibilities that go far beyond the role of traditional grandparents. Many grandparents live on fixed incomes, so added support helps ensure the children or child's needs are met without creating additional hardships. Prioritizing grandparents ultimately strengthens family bonds and allows children to remain with loving, trusted caregivers rather than entering unfamiliar systems. Thank you.
Absolutely. Thank you. I don't believe Dahlia Allen is here. She's online. Okay, Dahlia Allen, you're up next.
Good morning, everyone. I am a little hoarse, so I'm gonna try to speak really clearly. Good morning, Chairperson Parker and members of the committee. My name is Dalia Allen. I am a proud mother of 5 children, a resident of Ward 8, and an advocate for families in our community. I'm here today to voice my strong support for Bill 26-0406, the Streamlining Service for Children Amendment Act of 2025. As a parent who has had to navigate multiple systems here in DC, from education to health and behavior services to after-school supports, I know firsthand how overwhelming and confusing it can be when agencies do not communicate with one another. When services are fragmented, it becomes the responsibility of the parent to play case manager, advocate, translator, and follow-up coordinator all at once. And while we are fighting through that process, our children are waiting for the help they need. I have experienced delays in my own children receiving services simply because referrals were stuck between departments or forms needed to be repeated over and over again. Every extra week spent waiting is a week of lost progress. And for children, timely support can make the difference between falling behind and thriving. This bill will help change that by creating stronger coordination across agencies that serve children. We can reduce delays and confusion for families, prevent children from falling through the cracks, ensure that services are guided by the needs of the whole child, not the limitations of a bariatric system. I'm sorry if I didn't say that right. Bring more equity to families in wards like mine who often face the biggest barriers to accessing support. Parents should not have to fight this hard for basic services. We should be able to spend more time supporting and raising our children and less time navigating red tape. Investing in coordination is not just a policy improvement. It is a declaration that DC values its children, especially those who are most vulnerable. When we streamline access to services, we are building stronger families and a stronger future for our city. For families like mine, this bill is not an abstract idea. It is hope. It is relief. It is giving our children what they need and deserve, a system that works for them, not against them. I urge the council to pass B 26-0406 and continue to make children and families a top priority in the District of Columbia. Thank you for the opportunity to testify, for your continued work on behalf of our cities, and our children. I'm happy to answer any questions. Thank you again.
Thank you for your testimony. And you did great. No need to apologize. Next, we'll have Leah Costellas.
Perfect. Thank you, Council Member. Good morning, Councilmember Parker. My name is Leah Castlas. I'm a senior policy attorney at Children's Law Center. Today, my testimony will focus on the Streamlining Service Act, which seeks to address the lack of interagency coordination focused on children in the district. We share this concern and understand the need to strengthen coordination and accountability for government agencies that work with children and families. My written testimony addresses other bills from today's hearing. Children's Law Center currently participates in several advisory committees, task force, interagency councils, and coordinating councils covering education, homelessness, school-based behavioral health, and child welfare. Therefore, we see both the utility and the difficulty of operating cross-government collaboration. One of the main challenges we have seen is the struggle to carry over the priorities and action items identified in interagency spaces to the practices of individual agencies. The district agencies continue to operate in silos despite the numerous spaces created to break down those silos. In our experience, there must be more than a requirement for agencies to meet. If the district wants to see actual impact and outcomes for interagency coordination, there must be a mechanism in place to hold the agencies accountable to ensure the priorities identified are carried over into agency practice, policy, and implementation. Therefore, we appreciate the proposal to create the District Office for Children as the entity to convene and hold interagency council accountable. However, we have a few concerns. First and foremost, the District Office for Children cannot exist within CFSA. If the district were to create an office for children, it would need to be a standalone agency outside the Child Welfare Agency or any other established government agency, similar to what other jurisdictions have done, to support a more neutral, independent approach and allow for a broader scope. However, a standalone executive agency would not report to the council and would not provide the same level of independence intended by this act. Therefore, we believe the district should leverage the Office of the Ombudsperson for Children to meet the functions described in the act and to operate the interagency council potentially through MACAN. The Ombudsperson's core functions, effective oversight, systemic trend analysis, interagency coordination, and investigation in day-to-day problem solving, and its position as an independent legislative entity means it is in the right role to assist the council with holding DC agencies accountable for their role and services for well-being and positive outcomes for youth. The act also requires a coordinated centralized website for district families and children. Thanks to your leadership and funding, Councilmember Parker, the district is already expanding the functions of LinkU, and further coordination and investment could ensure LinkU serves this function. We welcome the opportunity to work with the committee on strengthening existing systems to accomplish the intent of the Streamlining Services Act. Thank you for the opportunity to testify, and I welcome any questions the committee may have.
Thank you for your testimony. I certainly have some questions. I'm sorry, I think I had skipped over Dante Massey.
It's okay. Good morning, Chairperson Parker and members of the Committee on Youth Affairs. My name is Dante Massey. I'm a proud district resident of Ward 7 and a relative caregiver to my younger brother, who is 16 years old and in high school, and my younger sister, who is 20 years old and who was seriously injured in a car accident last year. When my journey in kinship care started, I was caring for 4 of my younger siblings. I have been a member of the DC Kin Care Alliance Community Board for 6 years, and I am here today to speak in support of the increasing support for grandparents and close relative caregivers Amendment Act of 2025. I want to thank Councilmember Parker and Councilmember Allen, Bonds, Louis George, Pinto, and Robert Wright Jr. for introducing and co-sponsoring this legislation. This bill is an improvement on the current law. However, it needs to go further to provide equality between relative caregivers who are not foster parents and those who are. Foster parents can receive their subsidy until the child they are caring for turns 21, while in my case, the support for my siblings were only available until they turned 18. Right now, I get financial support for my younger brother, but not as much as a foster parent would. I don't receive any help at all from my younger sister. I was so grateful that this bill changed the termination and eligibility for close relative caregiver subsidy for the ages 18 to 21. It is a change that needs to be made. When the grandparent caregiver program subsidy was first enacted into law, it was designed to mirror the financial support given to a foster parent. Years later, the subsidy amount was greatly reduced to a minimum of 66% of the guardianship rate. Right now, the guardianship or foster care rate is $38 per child. This bill only provides for $27.92 per child. For my younger siblings, how is that fair? My sister and my brother do not deserve any less than any child in foster care. They do not eat any less or need less clothes or less toiletries or less transportations or have less activities than a child in foster care. They are not less. In closing, I want to leave with this. I'm not asking for special treatment. We are asking for equality, support, dignity, and recognition. Thank you.
Thank you for your testimony. And I believe that is everybody for this panel. Mr. Thomas, I wanted to thank you for your testimony. I take it to heart, both what you're saying in terms of parents should be entitled to legal representation because of the stress they're under and supporting them through the process. But also what I heard through your testimony is that close relatives also need support when they're stepping in to provide needed relief support for their loved ones. And so I take that to heart. Absolutely. Just make sure you push the button.
Okay, I'm glad you said it because okay, for instance, like my sister, when the children, they was cutting up in school and I had to step in, it was they just felt like their mother didn't pay no attention to them. She was stressed out and didn't listen to them. And I understand as I was growing up, as I got adult, my mother was going through that. And she's worked 2 jobs. And I give her my permission slip. She just go to sleep in bed. Felt neglected. But you're a child, you not understanding what adults go through. So I had to explain to them, but it was overwhelming. So I was just thinking, they stepped in and but I was just thinking if I had a chance for them to say, okay, well, my sister go to get stress management, mental health, go through all that, talk to people. It's good to go to, because I go to talk to a counselor, psychiatrist, because I've been through car accidents, been through a lot of trauma in my life. I still suffer through that where it came. So I've been through tremendous trauma. So, but while she's going through that, and I would go to her house, make sure the kids go to school, and just for a relative to step in while she get that, so trying to help the kids.
And during that process, did you receive any support?
Well, I was for years, I was trying to do things on my own,
Understood.
but it got overwhelming for me. And so you understand the impact for me being overburdened and she's being overburdened. So the kids was just basic, and then peer pressure when they go to school. All kids not bad. Some, and it's just the nature, And so when you feel left out, you begin to act out.
Absolutely.
And you stress it to your children, and they don't feel the love at home, which is love is there, but they're dealing with life situations and everything. She's doing everything she can, but she's stressed out. So a lot of times she need her time on her own and dealing with the children's father.
Well, thank you. I do want to get to others on the panel, but I did want to note that I take to heart your testimony, and you're echoing a lot of what we're hearing. And thank you for stepping up for your sister's children and your family. I think that we need more of that.
It put the family in there, to relieve that. And the housing also, is a very, if they could, we could put
Housing
that
is
together.
certainly, that is something we're keeping in mind, how we might have a joint hearing in the future about some of the connective issues between housing and family support.
And
So,
we have to look at the stress they go through. We can't just say
absolutely.
what they.
If you could push that
Right.
button again, that just so we don't get the feedback. Ms. Castellas, I wanted to come to you about the Office for Children, and it sounds like you're saying, yes, there is a need for these type of coordinating services, but it shouldn't live in CFSA. I'm intrigued by you saying it should live with the Office of the Ombudsman. Can you elaborate?
Absolutely. I think where that comes from is, and this is my interpretation of, the intent of the bill, but what I heard from, reading the bill and what the goals were is that the council especially wants to see more coordination amongst the many agencies, right? One of the biggest frustrations we see is that, there's Child and Family Services Agency and they're serving children in the child welfare system, but then there's children's services spread across the Department of Human Services, Department of Healthcare Finance, DC Health, all these various agencies. It's very spread across, and there is definitely a need for coordination. I think we heard that in earlier testimony too. And so, we understand that frustration. But if we were to have an office that lived within CFSA, that puts pressure again on the Child and Family Services Agency, which is already spread fairly thin, right? And also is an executive agency, right? And so if the council is looking to create more coordination and more insight into the practices of interagency, well, they should leverage their legislative office that they have, which is the Office of the Ombudsperson. And so we think that because that office reports directly to council, is a legislative office, is independent, that would give the council the type of insight that I think that you all are looking for. From this coordination.
That is helpful perspective. As I think about education or youth services, it's so disjointed across government. I mean, we can look at truancy. I was wondering how long it was going to take for me to bring up truancy. But like, how many agencies touch that? How many people are connected to truancy? Name any youth-related service, and it's like a alphabet soup of programming. And so I take to heart, and transparently, I will say we have been exploring the idea of this not living within CFSA, but being something broader. And I think your testimony is intriguing that it could be attached to an independent office that would allow for some of this work to live without maybe some of the bureaucracy and overreach of executive offices. The flip side of that is having buy-in from the executive will be important in order for there to truly be coordination. And so that is something that I'm thinking about. One other question I'm thinking about, how or what recommendations might you provide from other states that have these type of offices? I think you made reference in your testimony, like for instance, I know Maryland has some type of office for children type agency. Anything you would recommend that we look into or emulate from other jurisdictions?
Absolutely. And I'm happy in my written testimony, I'll have a nice chart that will break down some of these examples. So I will follow up and provide that with you all. But I think some of the examples I saw come up, I think the biggest thing to highlight, and this probably goes back to that this office can't exist within CFSA. A lot of the examples I looked at, they were their standalone. And I think, I think that was really helpful to have that outside of the child welfare system, especially as CFSA is moving more towards a prevention lens, and they are trying to coordinate that, especially through their warm line work and keeping DC families together. And so I think having that, I'm still, poking around. I haven't seen any that live outside of the executive, but I really do want to emphasize, I think living outside of the executive could be very helpful. Of course, DC not being a state does, give us a little, different structure than other states have and whatnot. So you see some examples that live more primarily in the governor's office. You see some that live within, another government agency like Human Services. And so definitely different state structures impact that. But I think even in that research, what I found really helpful was the emphasis of having an office for children. And I remember when we were working on the Office of the Ombuds for Children, it was originally had CFSA in its title, the bill did, that was talking about the office. And it was switched to the Office of Ombuds for Children so that it could have that broader intended scope around district children and families, not just CFSA involved. And right now that it is more narrow in scope in its definition of who they work with. But as we know, many families touch our child welfare agency, and our child welfare agency is expansive, and we could work to strengthen how that might impact other district children and families.
Fascinating. More to come on that.
Yeah, absolutely.
But we are thinking about expanding this, not to give too much away. Mr. Massey, thank you for your testimony. Thank you for stepping up to take care of your siblings' children. And I hear you loud and clear. I think that point you made, they don't eat any less, they don't cost any less, but why are we tiering our kids based on which system they're in? That is something I'm gonna talk to the director about. I will say what we sought to do here, because those subsidy rates are embedded in the code, is we went to the max of what was allotted in the code. We could go beyond that, but that is something that is top of mind for me. But it sounds like you are a proponent of maxing out as much as possible, or at least making equal the subsidies, whether you're in a foster system or a close relative.
Correct. And I thank you so much. I just wanted to say that we're doing the same job as a foster parent, and I don't think the children need to be separated or categorized in any level. So I just want to thank you for hearing me and understanding.
Understood. And Dalia, if you're still there.
Yes.
Yes, you talked about the Streamlining Services for Children Amendment Act and potentially reducing delays. Can you just give some examples of delays you would hope that this type of bill would reduce over time?
Yes. So I have a child who struggles with behavior problems, and I tried to get her connected way back when she was in I want to say first grade. She's now in third. And I went through multiple different agencies along with the school, and everything was not working out. I would get to filling out papers, and then they would get submitted. Then the other agency say, well, we didn't get anything. And my baby just kept getting delayed. Like her help kept getting delayed, which was starting to affect her academically. We've came a long way since then. I have been able to get her the help she needs. However, when it comes to that paper trail, that still is a big problem. We're having to keep repeating the same cycles over and over and over again. And then Sometimes things are getting misplaced and they're falling short with our children pretty much.
Absolutely. And this conversation came up yesterday. The State Board of Education met with the council. And we routinely talk about parents just not knowing where to go, or they go to one place and those folks aren't responsible for this service. And that's even beyond CFSA, which is again why I think this idea of expanding an office for children beyond CFSA has a lot of merit. So thank you all for your testimony. And if you have not yet submitted your written testimony, and if you could do that, that would be great. Thank you. I believe this is going to be our last panel here. Chris Gamble of the Children's Law Center, Michelle Booth Cole from Safe Shores, Stephanie McClellan from DC King Care Alliance, Christian Green of Eclectic DC, Salima Dofo, who signs up for every hearing and never shows, for ANC 8C. Christian Green, I am told, is virtual. And then Marie Cohen, the Child Welfare Monitor. All right, so we are going to go with Mr. Gamble. You may begin.
Good morning, Chairperson Parker and members of the Committee on Youth Affairs. My name is Chris Gamble, and I'm a behavioral health policy analyst at Children's Law Center. I'm also a former employee of Safe Shores, the DC Children's Advocacy Center, where I provided support as a client advocate to over 400 families. I'll be testifying today about the Child Abuse Investigation Multidisciplinary Team Certification Act. We support the bill's intent to ensure high-quality services are being provided by the Children's Advocacy Center that is a part of DC's MDT. My written testimony contains recommended language changes to the bill to make more clear that an accredited CAC must be a member of the MDT, but today I will address areas that need attention and action to support the vital role of CACs. Children's Law Center clients have benefited greatly from the strong forensic interviewing, victim advocacy, and trauma-focused therapy services provided by the district CAC Safe Shores. Before CACs existed, a child who disclosed abuse would typically have to tell their story to police, child protective services, a lawyer, a doctor, and even a therapist, each time running the risk of re-traumatization. CACs work to coordinate the activities of child abuse investigations, bringing together the members of the MDT so that information can be shared between agencies and children can be interviewed ideally once in a child-friendly environment. And they do this best when they are run independently from investigative or prosecutorial agencies. In addition to the intent of this bill, in order for youth in the district to continue accessing the critical services provided by CACs, the longstanding issue of sustainable funding needs to be addressed. Safe Shores' funding structure is not abnormal. It is in line with national trends for CACs in that the majority of its funding comes from government sources, in their case, OVSJG and CFSA. The annual grant amounts from OVSJG fluctuate and require a labor-intensive application process, while the funds from CFSA are the only dedicated line item for Safe Shores in the mayor's budget. Yet, inexplicably, the CFSA budget line is slashed by the mayor year after year and requires focused advocacy to restore. We need a long-term solution that treats CAC services as fundamental to child well-being, rather than putting their needs up for debate every year. Safe Shores supports the critical government function of investigating child abuse, so sustainable funding is a necessity. We urge the committee to work with Safe Shores on identifying sustainable funding mechanisms. By securing sustainable funding, while we understand that this bill applies to any CAC that would operate in the district, we must refute the idea proposed during this year's budget season that CFSA could or should operate a CAC. Yes, accredited government-run CACs exist, but one of the key tenets of CAC effectiveness, neutrality, would be lost under this structure. The integrity of forensic interviews is protected when they are conducted by a professional with no assumed or even unintentional allegiance to investigative agency priorities. and the trust that is foundational to the relationship between victim advocates and the families they serve is more easily achieved when the advocate's employer is not responsible for investigation or prosecution. Neutrality must be preserved for youth to receive the highest quality services. Thank you for the opportunity to testify, and I welcome any questions you may have.
Thank you for your testimony. Next, we will have Michelle Booth-Cole from Safe Shores.
Good morning, Chairperson Parker, committee staff. My name is Michelle Booth-Cole, and I serve as Executive Director of Safe Shores, the DC Children's Advocacy Center. Thank you for the opportunity to testify on the Child Abuse Investigation Multidisciplinary Team Certification Amendment Act of 2025. We get points for being able to say that, don't we? Safe Shores appreciates the bill's stated goal, ensuring that the district's Children's Advocacy Center is accredited, requiring the MDT to use a CAC, and requiring proof of accreditation status annually. We've also been informed that the committee's intent with this bill is to move away from naming a specific organization and statute in the interest of legislative neutrality. If the council ultimately decides to remove all references to Safe Shores from the DC Code that it is intentionally added over the years, what matters most is that child victims continue to be served in accordance with best practices. To accomplish this, 3 elements should be made explicit in statute: the CAC's coordinating role within the MDT, the continuation of existing confidentiality protections for CAC records, and a requirement that the CAC be accredited by the official national accrediting body, the National Children's Alliance. Now, I want to briefly discuss how the MDT CAC model actually works, as it's highly relevant to this bill. The foundation of the CAC model is partnership. The MDT and the CAC are inextricably linked, and each MDT partner has its specific role. MPD conducts criminal investigations, CFSA assesses child safety and family needs, the Office of the Attorney General and the U.S. Attorney's Office make legal decisions, Children's National Hospital addresses medical needs, the CAC, Safe Shores, coordinates the MDT's cooperative efforts, providing critical support to the MDT and ensuring trauma-responsive child-focused services that minimize harm and promote healing for child victims and their families. Because of this structure, language in the bill requiring the MDT to enter an agreement for services with the CAC should be removed because it doesn't reflect how MDTs and CACs function, here or anywhere in the country. Independence and neutrality are at the heart of the CAC model. This is why the vast majority of the 900 CACs nationwide are independent nonprofit organizations. In a system where government leadership and priorities inevitably change, an independent CAC provides continuity and singular focus on the well-being of child victims. We strongly support the bill's goal of requiring accreditation for DC CAC. To avoid ambiguity, we recommend that the statute explicitly reference the National Children's Alliance, which is the only accrediting body for CACs. And because accreditation is granted on a 5-year cycle, we suggest that the CAC be required to submit documentation at the time of renewal and notify the council promptly if accreditation is ever at risk or not renewed, rather than reporting every year. Finally, while Safe Shores is not a government agency, our role is operationally equivalent to that of a first responder, meaning we must maintain highly trained forensic interviewers, 24/7 MDT coordination capacity, and immediate crisis intervention and advocacy. As the council strengthens statutory expectations for the CAC, we respectfully ask that you also recognize the need for sufficient, sustainable, reliable, ongoing funding for the CAC so the district can respond to child abuse continuing in a strong way. Thank you for your time, and I'm glad to answer questions.
Thank you for your testimony. Next, we will have Stephanie McClellan.
Good morning, Chairperson Parker. My name is Stephanie McClellan, and I'm the Deputy Director and co-founder of DC Kin Care Alliance. We advocate for relative caregivers who step up to care for district children when their parents cannot. I come before you today in support of Bill 26-398, Increasing Support for Grandparent and Close Relative Caregivers Amendment Act of 2025. This bill goes a long way to address an important disparity between the experience of a child living with their grandparent, other relative, or family friend outside of the foster care system and that of a child receiving supports within that system. We applaud the extension of the Grandparent Caregiver Program and Close Relative Caregiver Program subsidies to those raising children up to age 21, rather than losing that support when the child reaches 18 years of age. However, we believe that the amount of the subsidy should be changed to avoid decreasing the maximum available subsidy that is currently in the legislation and to provide clarity and transparency regarding the amount and delivery of subsidy payments. The current foster care rate is $38, and the maximum allowant grandparent subsidy under the code is 105% of the guardianship or foster care rate. That would be $39.99 and 90 cents. By capping the rate at $27.92 per day, the legislation actually decreases the maximum allowable amount a kinship household could receive under current law. To address this, we propose that the amount of the subsidy stated in Section 2, Paragraph B, delete the amount $27.92 and insert in its place, quote, an amount between $38 and $39.90 per child per day. Lastly, we urge that the council amend the bill to include language requiring additional transparency be afforded recipients about exactly how much they will receive and when, so that they can budget and plan for their families. It is currently unknown how CFSA calculates the monthly TANF amount that is deducted from the monthly subsidy for each child. This is because there are households where all the children receive TANFs, households where some children either do not receive any TANF or receive a lower amount because they receive SSI or survivor benefits, and some households where the caregiver and her own children may also be receiving TANF. Moreover, the monthly TANF payment is not a one-to-one amount that goes up the same amount for each child. Rather, it is a rate that increases in variable amounts as the household size increases. As a result, the per-child TANF calculation will not always be the same. To address these issues, we recommend the bill require the subsidy agreement to include the following information: the net monthly rate to be paid to the grandparent for each child for each 30-day month, along with a calculation of how that amount was derived, an explanation of how the amount will vary for different length months, a notification that each payment is for the preceding month, the date the recipient was first deemed eligible to receive the subsidy, the amount of the first and second subsidy payments, and the dates they should expect to receive subsequent monthly payments. DC Kin Care Alliance appreciates your continued support for DC kinship families, and I'm happy to answer any questions.
Thank you for your testimony. And I believe last for this panel is Christian Green from Eclectic DC.
Hi. Good day, Councilmember Parker. I'm honored to testify. I'm a clinician who is CFSA's ombuds. My whistleblowing established the independent office of the ombudsperson for children appointed by and reporting to DC City Council. The office was not established because advocates screamed we could do better. Rather, the origin was an expert who whistleblew to DC City Council with the facts of failure, preventable fatalities, falsification of records, and facades of children's rights enforcements. When adults' emotions invalidate child safety, when liability outweighs validity, it costs us the truth, silencing children and families who are being stolen and buried. We know near fatalities are not being reported for public oversight as required. CFSA is rewriting history as if earned trust. CFSA has removed accountability through vague policy, placing responsibilities on kin, fictive or bio, who love their children enough to cover the failures of government. I see the good intent of streamlining, yet the impact would be akin to an abuser investigating and dispositioning on their own abuses, the truth nowhere to be found, making the public complicit. As ombuds, I heard, if you stop speaking to Christian, I will help you get your children back. The reality of that threat still exists in the present structure of child-facing agencies. A viable resolution. Use the ombuds as intended by legislatively pulling all child-facing ombudsmen to be under council to enforce rights and responsibilities for all who come into contact with, not just wards, in adherence with the 2012 South Capitol Amendment Act, shifting from creation to enforcement of laws, ombuds collaboration through expertise. All other duties of the operation of the state, akin to CFSA's policy planning and programming, should be pulled from each agency that serves children to form a new agency similar to OSSI. The Interagency Council for Children would fit perfectly under the legislatively established function of the ombuds with state-level collaboration of across-agency ops. Why? In DC, the chain of command is the director, deputy mayor, mayor, the president of the United States. Nationally, clinicians are a local function. Oversight is an executive state function. This would shortcut the echo chamber and conflict of interest that is every turn in DC politics. CFSA's org chart is blurry. OAG Aaron Colin is orged under, not next to the director. Intentional or not, this is breathtaking. The OAG is an elected official that represents the people. And when the agency fails, OAG is to hold the agency accountable for the public, not to protect the agency. If the ombuds had proper oversight purview and OPS was established as a state agency for all child-facing agencies, this clear structure would intentionally streamline all DC agencies as nationally, reset boundaries, create validity, and reduce liabilities that DC knows all too well. First, safeguarding children, protecting the clinical voices, and empowering parents who are involuntarily part of a fractured system. Thank you, Council, for letting me speak to our communities because power will always reside with the people. I'm available for questions.
Thank you for your testimony, and we can jump right in. Ms. McClellan, thank you for your testimony. And I know we've been at this for a while. I believe when I first joined the council, Councilmember Lewis George and I, on a one-year basis, increased the grandparent and close relative rate. And we will take a look at what you're talking about in terms of the reduction of that subsidy. But I'm thinking of what I heard from Mr. Massey on the previous panel. And if the subsidy rate for foster parents is at $38, then I don't see why it shouldn't be at $38 for grandparent and close relatives. So we will certainly look at that. And the intention was to raise that subsidy to its cap. I would also just note there is an effort on the part of CFSA to keep as many families together as possible, which I support and applaud. However, in doing so, we need to make sure families are supported in order to be able to take care of extra family members in their family unit. So again, thank you. Ms. Booth Cole, I wanted to come to you. I wasn't clear on whether or not it was the formal position of Safe Shores to support the legislation or oppose it. So can you clarify?
Yeah, I can clarify. Depending on the amendments that are made, we'll be in support. As it stands right now, no.
Okay. And those amendments include changing the accreditation to every 5 years or the submission of accreditation every 5 years, which is an alignment with when that accreditation is received, making sure that we name the national accreditation body, which I believe is the sole accreditation body, making sure that the CAC remains independent, and removing language about the coordination between the CAC and those MDT investigations.
The last point, actually, it's naming the CAC as the coordinator. It's basically aligning policy to 30 years of practice, because that's the role that the CAC plays wherever CACs exist. They are the coordinating body for the MDT.
What was the language you advised that we should?
There's a reference to services, having a services agreement with the MDT, and that's not the way we work. We have an MOA, which takes a lot of effort to get to update, but that's actually part of the role of the CAC too, is leading, coordinating the meetings where everybody comes together and discusses the MOA, what needs to be changed every couple of years. So we don't have a services agreement with the MDT.
Understood.
Yeah.
And this may be a little in the weeds. When we look at the code, the Children's Advocacy Center, or CAC, is defined as Safe Shores. Now, to me, that just seems inappropriate because Safe Shores is a nonprofit, is an organization that I support, and I believe you all do great work. but I also don't think you should be named as the Children Advocacy Center in the official code. So part of what we're trying to do is three things. One, ensure that there is a standard of excellence through accreditation, which I believe you all already checked that box. Two, making sure we address the murkiness in the code. And I think that is a result of different council members over time making changes to different aspects of the code that in no way should be interpreted as us trying to undermine Safe Shores. It's literally just to say our CAC now is Safe Shores, but the CAC should not be defined as Safe Shores, if that makes sense.
It's your prerogative.
Okay, I'll give you an example. If our DRS, this just came to my mind, the education provider for DRS is Maya Angelou Public Charter School. We shouldn't necessarily in the code say the education provider is Maya Angelou Public Charter School, if that makes sense. I think the code is different than practice, and we're trying to clarify. The third thing we were wanting to do and continue to want to do is exactly what you're testifying to, is how do we provide a level of continuity over time versus this back and forth every year when the mayor cuts it, we fight to get money back. In fact, I think the mayor cuts it because she knows we're going to go find the money. And that's what we're trying to stop. And so if by code, you have to have this accreditation, these steps have to be followed, then it makes it harder for the mayor to just haphazardly just cut Safe Shores and say someone else can serve that function. I do have another question for you. It was proposed that Safe Shores was going to be cut and those functions could be brought in-house to CFSA to execute the functions of what you all are doing, investigating, et cetera, et cetera. Why isn't that feasible?
Why the CAC functions shouldn't be absorbed by
CFSA.
one of the investigative agencies that is part of the MDT?
Yes.
Well, really what it takes to coordinate the efforts of a multidisciplinary team really requires a certain degree of neutrality, and it requires a body that doesn't have connections with government. And in my written testimony, I've really referenced kind of some of the advantages that we experience, particularly in engaging with children and families. There's a level of trust that we're able to have with community members because we are not part of the government. We are not part of investigative agencies. We are not part of removals. We don't make those decisions. And so I think, one, in terms of the standard of work and quality of work that it takes to administer a children's advocacy center, I've been there for 22 of the 30 years. It is a heavy lift. It's great work, but it is a heavy lift and it requires coordination and stability. What I do know about our colleague CFSA is that they have been understaffed chronically for at least 2 to 3 years. And so if you really don't have the staff to handle the scope of your responsibilities, that's one piece, but it really more has to do with neutrality, independence. The CAC is the one really who helps our beautiful social workers who speak one language and law enforcement who speak a very different language come together at the table around the needs of children, right? That is part of the role of the CAC, is getting all of our multidisciplinary team partners to stay in their lane, but also respect what each other does. I don't think you could assign that to one of the actual parties that does the investigations.
Understood. In terms of your facilities, where are you located?
You haven't been?
I have not been. I haven't been
We
invited.
have coffee for kids tomorrow.
Okay,
8:40 a.m.
I can't come tomorrow,
Okay.
but I would love to
December
find
day.
time to come. Yeah.
December day. So, this is a fascinating story too. I'll keep it short, but we are in the Bundy School, which is a renovated DC elementary school. At one point, it housed MRDDA, the Mental Retardation Developmental Disabilities Administration.
Say that fast 3 times.
The building was in such disrepair that it got written up in city paper, asbestos, all those things. Safe Shores had been looking for a permanent home and in the district since, I want to say, about 2007. No, actually, maybe before that. We were over at 300 E Street in Judiciary Square for many years. When Bundy was put on the table, the first time I saw the building was 2004. We moved in March 2010. And so we raised private dollars to bring to what the city, the capital dollars, the city had set aside for the renovation. We really try to take immaculate care of the space. DGS is our landlord. Children's National is our subtenant. We do pay a modest amount of rent. We don't think we should pay any given what we do, but we do that. And it's an amazing space. We really are recognized nationally as one of the top CACs, and there are 270 pieces of children's art in the building.
And is there, I'm assuming there is investigatory space in that facility where you can interview young people, examine, et cetera.
Exactly. That was part of the point of co-location. So all the MDT partner agencies have space in the building. CFSA occupies about 2/3 of the third floor. MPD has a unit on the west side of the building. OAG and the U.S. Attorney's Office, they do have space, but lawyers like to do things their own way. So they are there when they need to be. They're there when they need to be. And then Safe Shores has the second floor, which is our program space where we serve children and families. We have 2 forensic interview rooms. We have full-time therapists, a team of 5. We have our victim advocates, and we also have our youth advocacy initiative, which is separate, which serves teen sexual assault victims ages 13 to 17. So we are all there together. And when we Safe Shores helped design the building, it worked with the DC architects. When we got money, we furnished all of our partner agency suites. We got the same furniture so everybody would have kind of quality things. Again, it's kind of an arranged marriage, the MDT. And so we try to really take care of each other and make sure that everybody has what they need that we as a nonprofit
Understood.
are able to provide.
I have a few more questions. To your knowledge, are you the only organization that has received the national accreditation in DC?
Oh, yes. There's only one CAC, and standardly CACs work with a law enforcement jurisdiction, right? And so, for example, Alexandria has a CAC, Fairfax County has a CAC, Montgomery County.
What I'm getting at is, and I'm winking and nodding at you, if we make part of the code that the CAC has to be accredited,
yes, that will be Safe Shores.
then it would make it hard for the mayor to just cut it.
That's what I thought you were doing when you put that in.
That was in part the intent.
That was the good part.
Okay, that was the good part. So I'm trying to make clear, what is it that is giving you pause? Because the word on the street is that Safe Shores hates this bill.
Oh, well, like I try to tell staff, unless you hear it from me,
Okay.
don't assume that it's true.
And we're willing to work with you because I think the things you're mentioning here are reasonable, but I just wanted on the record
No, we don't
to
support the bill,
understand.
but understand that our work is so difficult. We do this dance every year in terms of budgeting. So it has been helpful to be able to refer to the statute, to the code and
I
say,
see.
hey, we're listed in the code. It was that's how in FY 2006, we originally were put in the budget by the Committee on Human Services at that time. Adrian Finty was the chair of the committee. Vince Gray was on the committee.
Yeah, I just don't I don't like the idea of you all being named in the code. I'll be honest.
It's your
I
prerogative.
think that's just bad practice, and it's not because it's you. I think I don't think a nonprofit should be named in the DC code as the defined anything. That said, I'm willing to work with you and your team to make sure this gets to the right place where you all can say this is good.
We appreciate that.
The
and we wanna work
intent
with you.
is to ensure that we can support the great work that you all are doing, that we can safeguard that work, but also do it in a way that just is above board. I'll just say that.
We like integrity.
Yes, yes. I have one more question there. Where do you receive and you don't have to give numbers, but can you speak to your funding? Like break down how much of it is private versus government?
Of course, yeah. So our budget's about $5 million, and we're at about 74% of our budget is public. And as my former colleague Chris mentioned, that's OVSJG grants that we apply for annually, right? Those are competitive, but because we're the only entity that does what we do in the district, we standardly do receive those, not necessarily what we ask for, but we do have to submit every year. And then there's the money that's put into the budget, the mayor's budget each year. What we talked about gets cut, put back. And then the remainder is foundations, individual donors. Those are really the main sources of our support. And that can vary because.
So what I'm hearing is if, God forbid, something were to happen in the budget, it would be nearly impossible for you all to operate.
It would be, yeah, yes. We have never laid off people. We've never, but yes, it would be a significant impact on our budget.
Understood. Okay.
And we do continue to try to diversify funds. It's a tough climate.
Understood. I was
no
gonna say
one's
75%,
fees.
but
No one wants to talk about fees.
75% on public dollars is a lot.
It's significant.
It is really significant. But the headline here, I support Safe Shores. I support the work that you do. The intent behind this bill is to support and protect that work in years to come. And so
appreciate
I
you
look
articulating
forward
that. Thank
to
you.
working with you. I'm going to stop there for the sake of time, but I want to thank you all for your testimony. And I've taken note on a range of things that you all have mentioned. And Ms. Green, thank you again for sharing your expertise and your passion with us as well. So with that, we're going to move on to our government witnesses. And the time is now 12:18. I'm gonna recess until 12:25. And then we will begin with testimony from Acting Director of CFSA, Tanya Torres-Trice, followed by Patrina Jones-Jess. And we will resume at 12:25. I am going to resume this hearing of the Committee on Youth Affairs. And before we jump into the director's testimony, if you could stand and raise your right hand. It is the practice of this committee to place government witnesses under oath. So Director, do you affirm under penalty of perjury that the testimony you're about to provide to the Committee on Youth Affairs is the truth, the whole truth, and nothing but the truth? Awesome. You may begin.
After I press the button. Good morning, Chairman Parker, council members, and committee staff. I am Tanya Torres-Trice, and I'm the Acting Director of the DC Child and Family Services Agency. I am joined today by Sheriff Dean Ibrahim, who leads our Office of Thriving Families, or the area where the Grandparent Caregiver Program is located. I am here to testify on 4 bills, B-26-398, B-26-409, B-26-412, and B-26-406 that were recently introduced before the DC Council under the Care for Youth Policy Package. Bill B-26-398, increasing support for grandparents and close relative caregivers. Since 2006, CFSA has managed a grandparent caregivers program to assist other types of caregivers. A close relative caregivers program was created in 2019. Together, we refer to these as the caregiver programs. The caregiver programs offer a monthly financial subsidy and other support to grandparents and close relative caregivers who are taking care of their relative kin. The caregivers programs' monthly subsidies provide a financial safety net for low-income caregivers who are raising children whose parents cannot care for them. Without the subsidies, caregivers may lack the financial resources to meet children's basic needs, putting those children at risk of entering the foster care system. If enacted, this legislation will create a flat subsidy rate of $27.92 for both programs and extend the eligibility of age range from 18 to 21 years old. Although CFSA supports the caregiver programs and understands the council's intent for this legislation, the agency does have concerns about some of the bill's provisions. Specifically, we do not support extending the eligibility age to 21 years of age. It poses the following concerns. There's potential fraud or improper payment. CFSA would be unable to verify if a youth age 18 or older who are not attending school or residing in the caregiver's household. We'll be unable to verify whether a youth 18 or older is working full-time. We could potentially pay subsidies for families with 18 or older not living in the household. There's also a potential for a waiting list. Participating caregivers will remain in the program for an additional 3 years, which combined with the increased subsidy rate would limit the ability of new families to join the caregivers program and could lead to a waiting list. As part of the application process, we are required to apply for the families are required to apply for temporary assistance for needy families, or TANF. By law, the caregivers program subsidy rate for each must be offset by the amount of TANF the applicant receives for children or the child. If this bill continues to move forward, CFSA would appreciate the opportunity to provide edits to the committee. Bill B-26-409, Empowering Parents and CFSA's Investigation Amendment Act of 2025. If passed, this legislation will require CFSA to notify caretakers in writing during investigation of their right to counsel upon the initiation of court involvement pursuant to DC Code 16-2304B1, available legal resources, and the availability of the ombudsperson for children as a resource for receiving complaints. CFSA understands the intention of this bill and recognizes the importance of empowering families to understand the resources available to them. Currently, CFSA provides parents with a pamphlet called Investigation, a guide for parents that includes parents' rights and responsibilities during an investigation. Additionally, there is a specific reference to the right of counsel if their matter moves to the court phase. CFSA will update the pamphlet to include information regarding the OFC as a resource for complaints. CFSA also contracts with the Children's Law Center and will refer families to CLC for legal services related to ancillary legal issues such as custody, housing, and domestic violence. We understand that some advocates believe that parents should have legal counsel present during the investigation process. However, this could cause confusion and create the following issues. Parents or caretakers may refuse to participate during the investigation and prevent their child from being interviewed until they have obtained legal counsel. If the investigative social worker is unable to see or interview the child and family or inspect the home, it could interfere and delay the investigation, impact the outcomes, and potentially put the children's safety at greater risk. CFSA is legally required to see all children in the household, assess for safety and risk, and harm and decide on the safety of the child and the household. Bill B 26412, Child Abuse Investigation Multidisciplinary Team Certification Amendment Act of 2025. If enacted, this bill will mandate, rather than request the involvement of an accredited children's advocacy center, and regulate its participation in the MDTR multidisciplinary team investigation of child abuse. CFSA understands the rationale for this bill and recognizes the value that a CAC brings to the community. I agree that a certified specialized body, clinician, or agency is required to perform the work of a CAC. Bill B 26406, Streamlining Services for Children Amendment Act of 2025. If passed, this legislation will establish a new district office within CFSA called the Office for Children, which will create an interagency council for children. The ICC will be comprised of representatives from the district government agencies, advocacy organizations, with the purpose of improving interagency engagement, coordinating communication to better serve children and families within the child welfare system. While I do recognize the intention behind the bill, I do not find such an office necessary for the following reasons. It creates duplication of services and resources. It creates additional bureaucracy or red tape, a new position for this work that is already being performed in many aspects. And CFSA is constantly working with individuals and organizations to expand resources. For example, we partner with the collaboratives to provide services and resources to district families and children. We will continue to partner and remain open to greater collaboration with our sister agencies, including those listed in the proposed bill and any others that may provide services to children and families. Thank you for the opportunity to testify. I look forward to further discussing our concerns about the bills and happy to answer any questions you may have.
Thank you. I will jump in on the grandparent and close relative subsidy.
Yes.
Essentially, you're saying to extend the age allowed for the subsidy from 18 to 21 and potentially increasing the subsidy itself could mean fewer people receive that subsidy and cause a waiting list. Can you elaborate? Like, is there a tranche of funds that you have available that
We don't.
that you are looking at, or is it funded year to year by whatever the mayor includes in her budget?
Sure. So we currently have in the Caregivers program 564 families and 859 children between both of the programs. So we did a fiscal analysis based on the information that we have to see the financial effect that this would have and potential for a wait list. We use the assumption of the number of program participants year over year. We see about 11 roll on each month and 26 age out of the program, so that's 18. Right now in our current program, the highest number of participants is ages 16 to 18. So we took all of those things into consideration. And if we broke it down a couple of different ways, I don't know if I just did something there. If, as is right now, the two programs combined receive $797,000. If we changed nothing at all, remain status quo in FY27, we'd be able to serve around the same number of families. We have not had a waiting list. We have been pretty good about that. And again, we are taking averages into consideration with these amounts. If we just increase the subsidy rate alone to $27.92, we would need an additional $2.46 million on top of the money that's already being provided.
And the subsidy rate, I'm sorry, is what now currently?
The subsidy rate depends. It varies.
So if we increase the subsidy rate, you're saying that's 2.4 million?
$2.46 million.
Got it. To serve the current population.
Current population only up to 18. If we increase the age to 21, we would need an additional $3.45 million on top of what's already there for both programs.
Sorry, give me that number one more to
Sure.
3.1?
$3.45 million.
4.5 million. I see. So altogether, we're looking at nearly 6 million more to serve the current population if we were to do both of those things.
If we were going to do both, we would need $10.763328 million.
Now, I'm not getting how you get to 10.
So
You're saying 2.46 million to increase the subsidy, and to extend to 21 is 3.45 million.
So $7,309,000 plus the 3.45 million equates the 10.76 million.
Okay. I'm sorry. I want to make sure walk me through the numbers again, because I think I'm missing something.
Sure. So would you like me to break it down by program or just collective? Like caregivers program as a whole?
Mhm.
Okay.
Mhm.
So as a whole, the programs receive 7.309 million right now today, funded in 26.
7.39
309. Mm-hmm.
million.
Yes, sir.
That's where I messed up. Got it. Okay.
And that is with varied rates currently. So if we moved to the 2792 subsidy rate with current programming as is status quo right now, they would total 7.356 million. If we only increase the rate, the subsidy rate of 2792, I'm sorry, that would equate to 9.771 million or $2.46 million with under 18. If we added 18 to 21 with our current population, and assuming the new enrollees came in as we've studied over the past couple of years, that would increase the amount to $10.763 million.
That's a lot of money.
It is a lot of money.
Question for you. When was the last time that the subsidy rate had been increased?
Sheriff Dean.
I think since the inception of the program, we've always used our subsidy rates for the 12 and older and 12 and younger. So I'll say we have not made any changes to that since we started.
And when did you start?
2006 and then 2019 for close relative caregivers.
So since 2006, the grandparent subsidy rate has not shifted. And since 2019, the close relative program has not shifted. And certainly our economy has. One of the things that I've heard, namely from grandparents, is just how hard it is to manage and survive just day to day while taking on these responsibilities. Let's talk more about the extending to 21. Essentially, your argument is, well, it will be hard to verify that the young person is even in this household, that we would be paying the close relative X number of dollars a year, but also there is a potential for fraud. Can you elaborate on the fraud part?
Sure. So currently our program participants must participate or apply for TANF. And so we have a data matching system with TANF to ensure that they did apply. Once an individual turns 18 though, they would have to apply on their own to become an adult. So we would not have, so what allows us now to ensure that the families are stepping forward to receive all benefits available to them. This would put these adults in a different category.
So if I'm 16, I have to apply. If let's say my grandparent is taking care of me and receiving the subsidy, I have to go apply for TANF benefits.
The caretaker has to apply for benefits.
The caretaker. So does that also then mean that they can't make but a certain amount of money in order to participate in this program?
Yes, they do have to be below the poverty level to participate in this program.
Got it. Got it. And would raising the subsidy rate impact the TANF and other benefits that they would be eligible for?
Potentially, yes. Yeah, except for Sheriff Dean is saying not SSI, Social Security is precluded in our calculation.
Okay. When was the last time you adjusted the foster parent subsidy rate?
It has not been adjusted since I have been here, to my knowledge, so it has also been quite some time.
And I can hear the witnesses testifying to say we are well below Virginia and Maryland and these other jurisdictions. And so what I'm getting at there is the testimony we heard from Mr. Massey today is that if I'm a grandparent, a close relative, or a foster parent, the kids eat the same, they're largely doing the same, they cost the same. Why would we subsidize families at different rates? What would be your response? Why does CFSA subsidize grandparent and close relatives separate from foster parents?
So the rate is something that we too were exploring increasing and have been exploring for the last year. My response is I agree with Mr. Massey. It is expensive to raise children. It is expensive and the costs aren't any different. We are proud of this program and very much have not had a wait list and also advocated to add the close relative caregiver portion to this program. My response is we understand it is expensive to serve children. We want to serve as many families as possible. And we are at a place where we are, again, would love to discuss this further and love just to share these projections with you in hopes that we can come to an agreement.
Awesome. And so is it safe to say the agency supports increasing the subsidy, assuming money is available to do so, but is against extending the eligibility age to 21?
Yes, that is correct. Assuming the funds are available. Yes, that is correct.
Okay, that is helpful. I wanted to come to the Empowering Parents in CFSA Investigations Amendment Act. And essentially we've heard, I thought, super compelling testimony today about the stress, the hardship of a parent being under investigation by CFSA. There was a bit of conflicting testimony where we heard, well, parents don't know when the investigation is over, but it did in fact sound like parents do hear when the investigation is concluded. What is the policy of the agency in terms of notifying families when an investigation starts or ends?
Yes, so the policy is they are notified when the investigation begins and when it ends, if it's taken through the full course of the investigation. So you heard somebody say they received something in writing, but you also heard somebody say that it was a phone call. If there is a formal court process when the investigation ends, they will receive something in writing. And also at the onset of the investigation, we do have these pamphlets, which I did bring for you today.
Awesome.
To share that families are given.
Thomas, if you can, I would love to see this pamphlet. So if it goes through the court proceeding, it sounds like they will receive a formal written notice to say the investigation has concluded.
Absolutely. And if it doesn't go all the way through the formal or taken to court and it's an investigation, as you heard the mother say today, she received a phone call. And the social worker should be in constant communication and let the parent and family know that they are no longer being investigated.
Are there instances where you believe parents are not receiving either of those, a phone call or a letter, to let them know that the investigation is concluded?
I would surely hope not. I'm not aware of any instances, but I would be open to taking that feedback and ensuring that if it's not standard practice, we do that.
Okay. And what you're handing me, I'm assuming, is a brochure you hand out to families. Is this just available or is this at the launch of an investigation?
At the onset of an investigation.
So the investigation process. Why is CFSA contacting me? CFSA got a report that your child may have been abused or neglected or may be at risk of abuse or neglect. District law requires CFSA to look into all reports of suspected child abuse or neglect. So essentially, I'm assuming your argument is we're already doing this. We notify families of their, I don't know about their rights, but at least why we're contacting them. Is there resources included here that says here, oh, I turn right to it, my rights and responsibilities? Okay.
Now, there is also language on page 8 that does reference the ombudsperson, and in my testimony is where we do acknowledge we could make this language stronger and
Mhm.
update this to include contact information for the ombudsperson.
Got it. As well as under my rights and responsibilities, I think it could be strengthened to say, here are resources, places, offices you could reach out to. I'm glad to see this, but also if I had questions, I don't know who I would turn to if I were reading this.
We direct to the social worker, but
Yeah.
to your point, we will revise this to make it stronger.
Okay.
Mhm.
So that was one issue. We talked about when an investigation has concluded. When is a parent notified that they are under investigation?
The parent is notified that they are under investigation when we come to their home. And if we open a official court proceeding, they are given notification from the court, a notification of their.
That could
needing to
be
hear.
many months down the line if you're going to court. I imagine there is a preliminary process that CFSA is trying to collect evidence,
Up to 45 days, yeah.
45 days. So
Mhm.
in that 45-day window, are parents notified that we are screening you, looking at you, investigating you, and concern to allegations of abuse and neglect?
Yes, yes. Parents are one of the first people we try to contact. And then the collateral contacts come into play. But yes, parents are notified at the early onset.
And then I'm assuming it's your testimony that parents are notified and then they're given this as to share what their rights are. We heard some testimony, and I looked at this personally, and I'm not a lawyer, I just play one on TV.
Mhm.
But the right to counsel is a significant thing. It's not just, it is a right to counsel provided by the courts, as I understand it, and my team will correct me if I'm wrong. And that is already the law, that parents are afforded a right to counsel if and when they go to court.
Correct.
What some advocates were wanting was a right to counsel at the onset of an investigation. So at the beginning of that 40-day window, even before you get to court. And I believe our research concluded that no other jurisdiction in the state provided that. Is that right? No other jurisdiction that we are aware of provides a right to counsel on day one. Are you aware of any?
I am aware of the state of Texas.
The state
Actually
of Texas
does, and we'd be happy to share that finding with you.
okay, so there's one. And what are some of the findings there, or lessons learned, either good or bad, in your experience of what Texas is doing?
I have not reached out to the state of Texas, but would be interested in hearing more about it because they are the only state.
Okay.
And I, again, would be happy to talk to them
And
about that.
we'll do some more research on that too. And what I heard from your testimony, and something that is sensitive to me, yes, the chief goal is to keep families together, but really the North Star is to keep kids safe.
100%.
And sometimes that means the kid can't be with the family and can't be with mom and dad. And what I think I heard through your testimony is that a right to counsel could gin up, block, mess up an investigation, which keeps a kid in harm's way, potentially.
That is correct, potentially.
Okay. What this bill seeks to do, we opted not to move the right to counsel at the very beginning of the process, but at least to ensure that parents knew of their rights and right to counsel. And so perhaps this would suffice, assuming we beef this up with contact information. They can reach out to X person, they can reach out to the ombudsman's office. I think the bill requires the ombudsman's office to have a sort of hotline in order to answer questions, because what I think is also compelling, and we hear from parents, is, well, I've just now spoken to CFSA 3-4 times in this 45-day window. I've incriminated myself. I'm not really sure what their angle is. And now what I shared is being used against me to try to take my kids away. And that is what we wanted to address to ensure that parents knew their rights and we keep kids safe.
And that is absolutely our intent with this pamphlet. But again, recognize we can add and strengthen the language to ensure that that intent is clear.
Okay, so it sounds like you all are supportive of the intent behind this bill. Is that fair?
That is fair.
Okay. This is easy. Great. We're gonna move on, and I'm happy to work with you to make sure that if this is the resource, that we're on the same page.
Appreciate it.
Let me ask this. We heard from the Mothers Outreach Network that they are the only known entity that is providing legal representation to moms under investigation. Is that your knowledge, or are there other organizations that you all are working with that is providing legal representation? And the reason why I'm asking that is because should someone reach out to the ombudsman's office or somewhere else and say, I have a question or I want to talk to someone, is it that we just send them to the Mothers Outreach Network, or who else do you know operates in the space?
Bread for the City, Legal Clinic, Children's Law Center, DC Kin Care Alliance, Georgetown University, Legal Aid Society, Neighborhood Legal Services are some others that I am aware of. That they have
And I
active
do
free legal
recall
services.
there being a distinction between that initial investigatory process and the court proceedings. And so I think that breakdown too could be helpful to say, if you're in this phase, here's who you could reach out to. If you're actually being called to court, here are some other resources. So, all right, then we had the Streamlining Services for Children Amendment Act of 2025. We had pretty compelling testimony from the Children's Law Center, which said, this is great, it shouldn't be within CFSA. I'd imagine you're saying also it shouldn't be within CFSA. We also heard testimony from a parent that talked about delays and potential delays, and there needing to be greater coordination. How would you respond to the idea that these services are needed, but it may not necessarily work best under CFSA?
Sure. So first I would respond by saying that of the, I believe, 11 agencies, government agencies listed, CFSA personally has MOUs or works with them. The one that we don't have an MOU, but we do partner with them, and that's the District of Columbia Public Library. So I would say that we coordinate, but I do understand that a family can get frustrated with trying to navigate the system. I do not believe that this office should live in CFSA.
And can you just elaborate why? I know you mentioned that, but just again.
For some of the same reasons that the witnesses testified on today. So if the intent, I believe, is to improve collaboration across systems, it'd be a government agency, it'd be adding a layer into the government agency. I believe that's how I could be wrong, but how they are seeing it. And I also believe that there are functions that are doing or attempting to do some of this work, including the Ombudsperson for Children. MACAN is a member, a body that brings together parties from across the city. Again, I 100% believe in collaborating. We should be collaborating. We should be trying to make services more accessible to our residents, but I do not believe that it should live in CFSA.
And can you walk me through like how CFSA collaborates with other agencies on issues? And like, how is that collaboration coordinated, if that makes sense? Is it at your level? Is there someone dispatched to own that? Is it with the city administrator? So let's say CFSA and our friends at DRS, or CFSA and DC Public Schools. How does that type of collaboration work?
So sure, in addition to the MOUs that we have for the data sharing agreements or and other agreements, I have a listing of all of the ways that we collaborate, whether it be from sitting on committees to address education or juvenile justice issues across the city. You didn't mention, but with the MPD, we meet regularly to coordinate around the children and families that we are seeing and the issues we are seeing. It is at my level too at times. I just got a call yesterday from Dr. Bazran who said, hey, I have this family. She's not system involved yet, but it could be headed that way. Can we get our teams together? So what do? We collaborate together to try to support this family, not system involved, but we want to prevent it from going that way. So it is through the formal processes of the MOUs, but also from our ongoing work with all of the agencies and community partners to support the families.
And let's talk about MPD, because that's something that has come up before. So you have kids in foster care that are now being picked up or are truant and or violating a curfew. I have so many questions, but it sounds like you and or your team is meeting regularly with MPD to reflect on who those kids and families are. Is that fair?
That is fair. DYRS, DBH, DHS, and MPD.
And are those are all of you meeting at once, or are these different conversations?
It depends. So with DYRS, the teams meet at team level, but there is also a management team level where we bring forward young people who may not be duly jacketed, but are maybe headed that way.
Seems to me that we should just have a big corral and like, all right, little Johnny, who touches this kid and their families? Like I appreciate the coordination that is happening on a one-off basis or for this family, but what is routinely missing, not just with CFSA, but across government, is just the many overlapping pieces that we overlook. But let's keep going. So
Okay.
MPD, let's say a kid is picked up for curfew. This is tangential, but then how is that foster parent held accountable if they have a kid that is now being picked up by MPD?
We would counsel them on the need for them to parent the child in their home and hope to see behavioral changes. Are you saying, would we? So there are times where foster parents who are called here, who come to CFSA and really provide a great resource for our children. But there are times when parents should not be parents. So if we have issues with parents over time and we provide them training and support through their resource parent support worker and through their social worker, and they still aren't able to meet the needs of the child, or they're not taking the directions or resources given to them, there are times where we have to discontinue fostering of their home.
And how often does that happen?
I could get you numbers on that,
Okay.
but it does happen.
This may not be fair, but it just strikes me as though, like, if I have a wayward kid and it's my biological kid, it seems like CFSA may be tougher on me than a foster parent who has a wayward kid that is going down the wrong track. And I haven't heard a lot of instances where CFSA is leaning in on foster parents to say, get it together. Like,
You should come to CFSA on any given day.
Okay.
Those conversations happen all the time. They happen with our social worker. They happen with our resource parent support worker who supports directly the resource parent. And the facts are, we do have young people who are have been through a lot of trauma, who are experiencing behavioral and mental health crises, and they are difficult to parent, whether they be in their own home of their parent of
Yeah.
origin or our resource home. So just like we have our resource parent support workers working with our foster parents are calling us saying, well, what do we do? So it is on CFSA to support them. So we absolutely have those conversations with the parents. And sometimes the children in their home are too much for them, and we do have to make the decision to move them from their home.
And again, this is tangential, but while we're here, I've also heard that if I'm the bio parent, my kid is no longer in my home because they're with a foster family, but maybe I still have contact. The kid gets in trouble somehow. I'm not notified, nor necessarily should I be, I guess, as the bio family. But it seems like there's something there. There is a gap there between the bio family, the foster family, and kids that are being picked up by MPD and or interacting with DRS, where the committee keeps hearing that there is some grievance there, or there is a lack of transparency communication. And we'll love to just work with you on that. Zooming back out, in terms of the coordination, it seems to me that there needs to be a greater scale of coordination that perhaps is happening. And that's not a fault of CFSA, but like, how are we identifying the at-risk youth in the city and mapping out for each of them which agencies they're touching and which programs and resources we can get them? This type of office would be able to provide something like that. And I think I'm persuaded perhaps it's not CFSA's responsibility to do that because of the many different touch points that exist outside of your agency. I'm just thinking out loud. I was also intrigued by the example that was given about the mom with the 15-year-old kid that was then under investigation. So if I'm being transparent, it was a heart-wrenching story, but I was like, oh, here's an example of educational neglect. CFSA is pursuing educational neglect. I know you said that. I believe you. But it was good to hear it actually is being prioritized. Can you talk through for kids older than 13, where it's the Office of the Attorney General's responsibility to pursue those truancy matters, how you're coordinating there in order to pursue educational neglect?
Sure.
Because
So,
I believe the kid in that instance was 15, if I recall the story.
yeah. Yep. So we do work with the Office of Attorney General. Again, our goal is to try to work with the family first if they are brought to our attention, regardless of age, to reconnect them to education, reconnect them to whatever services and supports they need. But we do work with the Office of Attorney General. I can't speak on why or how they choose to prosecute their cases or move their cases forward.
Of course.
But a whole office is
But
upstairs.
clearly, at some point, you're receiving a file. So the referrals are going to court social services. Court social services is kicking them to the Office of the Attorney General. At what point is CFSA getting involved to say, we too are going to actually pursue this case for educational neglect? Because I was under the impression for kids older than 13, that was not a focus of the agency.
Not that it's not a focus. We would get re-involved if there were another call on abuse or neglect of other types. So educational
see.
neglect is only investigated for age 5 to 13 for CFSA. So if we received another call from whoever regarding another allegation, we
I
would get
got it.
re-involved.
I got it. And through that other investigation, maybe educational neglect comes up.
It could.
Understood. Okay. What is CFSA's experience with the Interagency Council on Homelessness?
Sure. I sit on the council and participate in regular meetings, as does another colleague of mine. She sits on the youth council and speaks on behalf of our youth aging out of the foster care system.
And how would you say your participation has impacted or improved CFSA's work?
I believe that it gives insight into individuals who were previously system involved. The community often speaks on the services that are working or not working for them. So for me, I often think about our young people who are aging out of the foster care system and our responsibility to prepare them to transition to stable housing. So for me, it gives me direct insight into the community and how they are experiencing our services and resources as a whole.
What challenges have you experienced with the Interagency Council?
Myself particularly, I have not experienced any challenges.
Okay. And what I'm getting at is what recommendations might you make if we were to move forward with this type of interagency coordinating council via this legislation to ensure that it's impactful to and helping us reach our goals?
I would love the opportunity to put some time and thought behind that specific question and get back to you.
Okay. Is CFSA aware of any child facing programs and services that you believe are redundant, duplicative, or inefficient? And I know the answer is of course, but
I am not aware that we have, I believe that we serve many of the same people and so many of the same families, I would say. But I would say that CFSA services are unique to the populations that we serve.
I'll give you an example. I
Sure.
spoke to a school leader and the school leader talked about, well, I need an office space just for social workers and all the people that are working with the kids, because I have a social worker from CFSA, I have a social worker from maybe, or someone from DHS, I have this person, that person. and they're all trying to do the same work, and including the school staff. That's a very high level example, but I hear it routinely. Again, what we're trying to get at with this legislation is how do we streamline some of this so that we can be more impactful in reaching young people and their families?
I do understand the intent.
But you're not aware of any redundant or duplicative or inefficient programs?
I believe we have, I believe that we collaborate well, and I believe that we have similar positions in each of our agencies across the government that could be performing similar functions. I can speak on CFSAs, and I know my charge is to investigate abuse and neglect, but I also know that I have educational specialists in-house, and I have nurses, and I have other professionals that are also in other agencies. Now, I can't say that I believe they're duplicative because they're serving and working to the population we are expected to serve.
Let me ask this. So if you have a kid with a social worker from CFSA, how do they interface with social workers or counselors or therapists from other agencies? Let's say they also have a DBH therapist and a social worker from DHS and a counselor from DCPS. How are all of is it the expectation that that CFSA social worker is coordinating with all of those individuals?
It is the expectation that we take the lead.
Okay. But what does that look like? Is it a meeting or is it
Yeah, so each child has a case plan. There's an individual case plan and a family case plan. So it is the expectation that the social worker take the lead on the case plan, and that includes incorporating the educational professionals, the community providers, a therapist, anyone in the child's life. It is the expectation that the social worker take the lead on coordinating the services and resources, because it is also our goal not to overburden the children and families with duplication of services or with 3 therapists or with 2 educational specialists. So it is our responsibility to take the lead.
Understood. Okay. And then the other bill was the Child Abuse Investigation Multidisciplinary Team Certification Amendment Act of 2025. I think that's pretty straightforward, and I feel pretty clear there. So I don't have many questions there. But let me ask this. How does CFSA currently partner with Safe Shores when conducting investigations into child abuse?
Sure, we refer children for investigations to them when they are sexual in nature or egregious crimes.
And I dare ask this question. Is there utility in ensuring that another accredited nonprofit do this work in the event that Safe Shores is no longer a viable option?
I believe that an accredited body should do this work.
An accredited body. Understood. I know during the budget process, it was said that the goal was to bring some of those services in-house. I recall the explanation was that you all would have to outfit your offices and rehab things. Have you made any progress on that? Is that still the goal?
That is not, we have not made any progress on that, but we were exploring that at one time, yes.
Okay. I'm gonna go back to the empowering parents.
Okay.
How is counsel provided to families in neglect cases? Does CFSA play a role in that, or is that purely through the courts?
So it is through the courts. They are assigned an attorney through the courts.
And do you weigh in on that process at all?
No, we do not.
Got it. Okay, I think I've exhausted all of my questions. Let me just look here. Are you aware of the pre-petition legal counsel pilots being run in New York, Michigan, or Washington State?
I am aware of the one in New York, but not of the others.
Any takeaways, lessons learned?
No, not at this time.
Okay. I think that's it. I think this is pretty straightforward. Thank you, Director, for your testimony. We will be in touch and follow up. Just to recap, on B26-398, increasing support for grandparents and close relative caregivers, Amendment Act of 2025. It sounds like the agency is supportive of increasing the subsidy rate, but has concern about extending the eligibility to age 21. You would prefer, it sounds like, keeping that as the status quo at age 18. For B26-409, Empowering Parents in CFSA Investigations Amendment Act. It sounds like you're saying a lot of this we're already doing. We're willing to work together to beef up our handouts that we already provide parents. Communication is readily available to parents in terms of when investigations open and close. It is more formal when it reaches courts. But outside of this, sharing more information from the Ombudsman's office, I didn't hear opposition to that. Okay. B26-412, Child Abuse Investigation Multidisciplinary Team Certification Amendment Act of 2025. The headline, whoever it is, they should be accredited. And making sure that we're all in alignment there. But it is safe to say that you all have a collaborative relationship with Safe Shores.
That is safe.
Okay. And then B26-406, Streamlining Services for Children Amendment Act of 2025. The agency is not supportive of this type of function within CFSA, although there is room for greater coordination across government for youth services.
I believe coordination exists. I'm always open to greater coordination.
Okay. Awesome. Well, thank you for your testimony today.
Thank you.
Awesome. Next, we will have Patrina Jones-Jez, our Ombudsman for Children. Before you take your seat, if you could raise your right hand. Do you affirm under penalty of perjury that the testimony you're about to provide to the Committee on Youth Affairs is the truth, the whole truth, and nothing but the truth? Awesome. Thank you. And you may provide your testimony.
Thank you so much, council member and team, council staff. Good afternoon. My name is Patrina Jones-Jez, and I'm serving as the Ombudsperson for the Office of the Ombudsperson for Children. I appreciate the opportunity to testify at today's hearing regarding proposed legislation affecting the district's children, youth, and families. Today's testimony will focus on 3 of the bills for discussion: Empowering Parents in CFSA Investigations Amendment Act, Increasing Support for Grandparent and Close Relative Caregivers Amendment Act, and the Streamlining Services for Children Amendment Act. In regards to the Empowering Parents and CFSA Investigations Amendment Act, we support this bill as it promotes effective communication with a focus on providing caretakers with information about legal resources, including information about the Office of the Ombudsperson for Children. Our office has heard from parents who did not understand their legal rights pertaining to an investigation or legal resources available to them. We believe the rights of parents should be protected. Clarifying this information early in the investigation will benefit the family and allow for informed decision-making. We recommend defining caretaker in the bill if there are other parties that this bill would apply to beyond the biological parent. And regarding section 3B, we recommend changing the language to reflect that the interview will be conducted early in the investigative process and include a time frame for sharing this information. Further, this information should be provided in writing and the date of dissemination tracked. By holding the interview at the beginning of the investigative process, the child's caretaker will have an opportunity to ask questions about the process and receive appropriate guidance prior to case closure. If not already occurring, OFC also recommends that the parent or caregiver is provided with a brochure or some type of fact sheet at the first interview visit that outlines the steps of a CPS investigation so that the parent can refer to the document throughout the life of the agency's involvement for a more thorough understanding of the process and their rights. OFC feels that this would lead to more transparency in the investigative process. Regarding the increasing support for grandparent and close relative caregivers amendment, OFC supports this bill due to the critical need many grandparents and close relative caregivers face as they support the children in their care. Grandparents and relative caregivers who are not or no longer involved with CFSA often face challenges with providing for the children for which they support. For grandparents, they also must be informed of their options to ensure appropriate financial resources are in place as they care for their family's children. For instance, it is critical to express clearly to relatives information about serving as a kinship foster parent or legal guardianship, etc. With this information, relatives will be able to make informed decisions proactively about the level of financial and services access and resources needed for their family and the expectations and limits to those supports. We also support the continuation of the subsidy through age 21, which will assist the grandparents and relatives with providing for youth as they go through the process of transitioning to adulthood. And for section 104B, which addresses the subsidy in an amount of $27.92 at a minimum, we recommend clarifying whether the subsidy is per day or per day and per child. And finally, regarding the Streamlining Services for Children Amendment Act, according to the bill, the District Office for Children will engage youth and families external and internal to the child welfare system. We recommend placing this responsibility independently and directly under the mayor's executive office or with an independent agency. An example of an organization that may be better suited for implementing and leading the District Office for Children is the Mayor's Advisory Committee on Child Abuse and Neglect, or McCann. McCann is charged with several duties from a child welfare focus, including recommending approaches to improving coordination of services among public agencies, promoting public awareness of programs and advising on public concerns relating to child abuse and neglect in DC, and developing reports and plans on specific issues. We believe that CFSA is currently overburdened with critical child welfare responsibilities, i.e. child safety, child permanency, and the well-being of children in their care. And it would be more efficient to utilize CFSA's resources to support the agency's direct mission. Thank you for the opportunity to testify today on these important bills. I'm happy to answer any questions.
Thank you for your testimony.
Sure thing.
In terms of investigations into abuse and neglect, we heard conflicting testimony today from some saying, well, parents are notified when they are under investigation. They're not notified always when the investigation concludes. Then we heard from some that said they were notified. We heard from the director of CFSA that said it is policy that parents should be notified. What is your experience as you hear from parents, whether or not they are even aware when an investigation is initiated or concluded?
In terms of parents who have reached out to our office, there have only been perhaps one or two who had reached out with concerns about not knowing when their investigation had concluded. So our position is it's definitely an area to look at, and it's probably something the agency will want to tighten up, if you will. But in terms of the feedback we've received from the community, it's probably just been one or two complaints on that.
Understood. That is helpful. in terms of the Streamlining Services for Children Amendment Act of 2025, we heard testimony today from the Children's Law Center that said, oh, we should just give that to the Ombudsman for Children and and task them with doing it. What is your reaction when you heard that?
So I definitely see where there is alignment. When I look at our enabling legislation, we are charged with assisting with the facilitation of coordinating, like interagency coordination. That's in our mandate. And we've actually already done a little bit of that work. I can say in December of 24, we brought together a wide variety of agencies, everyone from Students in the Care of DC to Council on Court Excellence, and there were others present. I can give you a attendance list if you'd like more detail. And the purpose of that coming together was partly for us to introduce ourselves, because that's always on our minds, to get the word out that we exist. But then it was also an opportunity to talk about issues that affect the child welfare system. And there was a significant conversation that occurred in that meeting. We've also held in May of this year, I guess you would call it almost like a focus group, but it was focused on government agencies. And so we had a nice turnout for that. Department of Behavioral Health was in attendance. Children's Law Center was present. Once again, I can provide you with a list because we keep track of that, and I'm sure we have the notes as well that came out of that meeting. In that discussion, it was very focused around issues affecting child welfare, but also how can we work together? Like, what can we do as individual agencies differently to serve the system better? And we actually did not include CFSA in that meeting intentionally because we wanted these agencies to think about their role and not immediately kind of fall back on, well, CFSA has the capability, the authority, those things to do X, Y, or Z. So out of that meeting, I'm sure I have the notes for it, like I said, but one thing that stands out from that meeting is there was discussion about how our systems don't talk to each other. So there were certain agencies that felt like if their systems could talk to each other, there would be more efficiencies that they don't currently have in place. So we're already doing some of that work just for our own, so we have a finger on the pulse of what's occurring in DC around child welfare. But I think we could very easily transition over to a more formalized system.
And channeling Christian Green, who we heard from a little bit earlier, she would say, oh, the intent of the Ombudsman's office was always to be bigger than CFSA, that it was supposed to be far reaching when it was first brought to bear. And so that is something that is sticking with me. And I agree with you, our systems don't talk to each other. And again, that's not a criticism of CFSA, that's a government-wide thing. Our data systems aren't talking to each other, programs overlap, and the result is that oftentimes families don't know where to go. They're going from office to office. They're just calling, hoping someone can help them. And we feel that acutely in the youth space where we feel that acutely in the youth space. I'll just stop there.
Yeah, we've had some individuals who have come to our office in need of more so that help with the coordination of the system itself. So I appreciate what you're saying, because you're exactly right. When there's multiple needs on an individual family, and then trying to figure out who do I talk to and how do I navigate it, that assistance is definitely needed.
I think about even public safety in the city. We know that generally, but also with youth, it's a handful of, relatively speaking, it's a handful of young people that are often in the mix, if you will. And the same is true citywide. where we know the vast majority of our young people are doing the right things. It would be great if we could identify who are these 100 at-risk young people and how do we flood them with resources? How do we connect with their families? How do we connect with them at school, get them jobs, get them mental health services, wrap around them versus this piecemeal fashion. But I digress. So what I heard from CFSA is that this type of interagency function they already participate in, but they don't want to take on another bureaucratic function. I heard that loud and clear. We heard from the Children's Law Center that, yeah, this is great, but it shouldn't be within CFSA. I would ask you, do you think this type of function should live within CFSA or elsewhere?
My position that it should not live within CFSA. I will say that, I offered up McCann, and I think CFSA has a role in the coordination of McCann already. So McCann could be an opportunity because of its current charge, which could be enhanced perhaps to reflect what the bill is requiring. But in terms of as an agency, I mean, as I mentioned in my testimony, and I think it's come up in this in the hearing today, the agency is experiencing staffing, issues, short staffing. We feel like there's a greater need to focus on their primary charge, which is the safety of children, safety, permanency, well-being of children.
Understood. Understood. In terms of empowering parents in CFSA, has your office received any complaints related to parents not receiving their right to counsel during a neglect case?
We have not that I'm aware of. I'll certainly check back on that when I get back to my computer, but not that I'm aware of.
Have you received any calls of parents wanting to know what resources are available to them in terms of right to counsel?
Not offhand. Nothing's coming to mind.
What we hear, and part of the tension is we hear a lot of conflicting things and you have to kind of sift through and make sense. Like, are these one-off anecdotal instances or are these patterns and trends that we ought to address? And what we routinely hear is that parents are overwhelmed. Check. That's clear. Parents are confused. They don't know where to go. They're not receiving information from CFSA. And they don't know who to turn to. And part of what we were hoping to do with this bill is use the ombudsman's office as a hotline of sorts to say, here are legal resources available to you as a parent should you be under investigation by CFSA. Do you have an opinion whether or not that right to counsel should begin pre-petition or the status quo, which is provided if and when CFSA takes a case to court?
Yeah, our position is that the rights, parents' rights, should begin at the beginning of the investigation. Our position is that information should be provided in writing so that parents can kind of look back on it throughout the case.
Understood. So I'm hearing you to say day one of a preliminary investigation, parents should be notified in writing, here's your right to counsel, and you are under investigation.
That's correct.
We heard word of several pilots, and my committee will look in New York, Washington, and there's another one. Those are pilots. And then I believe Texas is a state that is actually doing this per the law, that parents are notified. Questions that would come up for me is, how is that impacting separation rates? How is that impacting the work of the child welfare agency? I prioritize family rights. I think chief among my concerns are we keeping kids safe? And so we will look into that more. I wanted to come to the grandparent and close relative caregiver. Does OFC have any data related to children aging out of subsidy eligibility while in care of a grandparent or relative caregiver? And if not data, Do you have any anecdotal evidence or people that are reaching out because there is a need for more support?
Your first question, nothing's coming to mind in regards to youth aging out of a family unit that was receiving a subsidy. But in regards to relatives reaching out, we have, because of the need for support, if I understand your question correctly, we have several. In fact, I would say at one point that was our primary complaint that we were receiving was from grandparents who were no longer involved with CFSA or not involved with CFSA, but had taken on the responsibility of being the caregiver for their grandchildren or their, another, relative, and not fully anticipating what it was going to require to maintain this caretaking role.
And in those instances, what do you do? Or what does your office do?
Yeah, so we do our due diligence in terms of identifying agencies that could be helpful. So, for instance, I'm thinking of a particular instance where a grandparent, she agreed to be the caregiver for two of her young grandchildren. She was a working grandparent, so she needed childcare. She needed her housing wasn't quite as stable as she had hoped, so there was housing assistance needed. We do reach out to CFSA, especially because these children had CFSA involvement, to see if they can help with providing services or connecting the family to services. But we also have connections in other agencies as well. Like we communicate with DHS and we communicate with other agencies. That's been, one of our goals is to understand the landscape of services in the district and know who to contact.
Do you have data that you could share with us, like how many of those types of calls you're receiving?
I think we could produce something for you.
Yeah, that would be helpful to back up the need. And what I heard from the director is, yeah, we support raising the subsidy rate, assuming money is available to do so. And I know people need more resources to survive in a city like DC. It was striking to hear that the subsidy rate hadn't been changed in almost 20 years. And we know inflation alone has shifted dramatically since then. In terms of the Child Abuse Investigation Multidisciplinary Team Certification Bill, does OFC interact with Safe Shores and its oversight capacity of CFSA? And if so, how so?
So we have interacted with Safe Shores. In fact, our initial interaction with Safe Shores was actually attending the Coffee for Kids that the executive director mentioned. That just gave us an opportunity to get to know them and hear about what services that they provided there at their individual facility. Since then, we have worked with them in regards to providing forensic interview training for my team. So they provided a wonderful curriculum for us.
And why might your team need that?
So because we talk to a wide variety of people, from grandparents, parents. Occasionally, we do talk to children. We'd like to talk to more youth. We felt like it might be or it would be another kind of tool in the toolbox as needed.
Understood. Relative to Safe Shores, any thoughts about their investigatory work that they are conducting?
Yes, I think it's highly important and critical for due to the investigative aspects of sexual abuse against children. I think they provide a unique resource that provides a great perspective that can be used not only in terms of the child welfare aspects of it, but then also from the law enforcement aspect as well.
Awesome. And so across, it sounds like OFC is supportive of all of the bills, but as it relates to streamlining services for children, Amendment Act of 2025, you think it should live outside of CFSA?
I do.
Got it. While I have you, there was a budget reduction for OFC.
Mhm.
What has been the impact to the office and the work that you're conducting?
Mhm. So, I need a moment to kind of gather my thoughts on that because we have had to kind of rethink some things. Certainly, there are legal requirements that we will continue to work towards, such as the crossover youth data and reporting. The person who was in the chief deputy role was very instrumental in driving that particular legislation. So, or driving that particular piece of the legislation. So,
And I can't remember, did we cut that role or was it the overall budget just reduced?
that role was not funded.
That specific role
That
was not funded.
specific
I got
role.
it.
Yeah.
I got it.
Yeah. And then just other supports from a more administrative aspect of our work, from policies to just kind of oversight of the, as we think through the investigative aspects of our work and what that looks like and what we're learning. I would say the systemic look really kind of was a partnership between that person and I on that particular aspect of the work. So, I mean, we have been impacted, definitely. We also have a staff person that has recently resigned. His last day is actually tomorrow. And so we're down to 3 people. But, we will continue on. We'll rehire for that position and just keep moving from that perspective.
Understood. Understood. Well, it's worth noting, I support the work of the Office of the Ombudsman for Children. And as we are thinking about the bills before us, I'm mindful that I don't want to add to the bureaucracy that is government. At the same time, we have to address certain gaps. And a clear gap is that there is a coordination gap across government. In fact, it is often said the DC government is resource rich, but coordination poor. And I think that is very true. We have a lot of programs, a lot of resources, a lot of people, but the way that residents interact with government is often with frustration because there's a lack of coordination. So anyway, I want to thank you for your testimony. I please follow up with that data because we will include it to inform the decisions we make next, but also as part of our markups. I will say, where do we go from here? This is now the second tranche of bills of the Care for Youth plan. The first tranche of bills we took up, it's a blur. Maybe it was last week or 2 weeks ago with Councilmember Pinto and the Committee on the Judiciary and Public Safety. Our hope is that all of these bills will move towards markup in the coming weeks, certainly by early next year. There's a third tranche of bills that we are anxiously awaiting to be taken up by the Committee of the Whole that relate to education, and that will conclude the Care for Youth plan. We will also have the confirmation hearing for Acting Director Trice in a few weeks, December 11th, if I'm not mistaken. And I'm naming all of that because for the committee, what we see as our key priorities is making sure that we have the right people in the right seats and that we're addressing the gaps in the systems as it relates to our oversight over the last year or so. So with that, I'm going to conclude today's hearing. The time is 1:39 p.m. And this hearing of the Committee on Youth Affairs is now adjourned. Thank you for joining us.
Thank you so much.